Hello, hello, hello. Good afternoon. It is May 24th. We are here today to cover the Petito Laundrie hearing in the civil case. If you are just catching up on this case, I covered it on the Emily Show podcast today. The family of Gabby Petito, the parents of Gabby Petito, have sued the parents of Brian Laundrie for intentional infliction of emotional distress. This is mostly a discovery hearing, but there is one key piece of evidence that they are going to be arguing over in court today. The Petito family wants a letter turned over in discovery that was written by Roberta Laundrie, as affirmed in her own affidavit in these motions, that not only referenced getting a shovel to help bury a body, but also baking a shiv into a cake to help Brian Laundrie break out of prison. The Laundries are arguing that that letter is not discoverable. It's not relevant. It was undated. It was written before the time that Gabby Petito was murdered, and that it should not be turned over in discovery. At the end of the day, I think the Laundries will get this letter in discovery, and then we will see motions in limine before trial to keep this letter out. The Laundries arguing that it's more prejudicial than probative. The Petitos arguing that in this case, it shows that Roberta Laundrie knew that Gabby Petito was deceased and was talking to her son about what would happen if he goes to prison in this case. This is a huge court hearing today. It's a discovery hearing. We don't normally get to see cases at this point in discovery, but this letter being turned over or not is critical. And we're seeing attorney Stephen Bertolino, who's a defendant in this case, in court for the first time in person. That should tell you how critical this hearing is to these parties. So we're going to join court. It started a few minutes ago. They had some tech issues. I'm going to put the closed captions up, put it on 1.25, and talk you through what this court is doing. Again, it feels like a normal everyday in court, but the impact of this ruling is big for both parties, which is why I wanted to watch it today. And you might have seen me a little earlier with Hey JB over on WFLA. It was a delight to be there with him. They don't have closed captioning on their feed. Otherwise, I would use their feed. So we've grabbed a feed that does have closed captioning. And we're going to roll the intro. It's getting hot in my office today already. So hopefully you can't hear the fan. Let's get started, shall we? Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it. All right, law nerds, we're going to join court here. Gabby Petito's parents are in court. Brian Laundrie's parents are not in court, have not been in court on any of these hearings. So we are going to get started. I will be getting to questions at the end of this hearing. So if you have questions, the mods and I will try to grab them. We will grab your super chats. We will get to it at the end. And of course, I will be breaking this down as we go and trying to minimize my talking over. Minimize. But you know I talk over some. Let's get into this hearing. You let me know how the sounds, and if we need to boost it, we absolutely will. All right. My understanding here today is that we are noticed for plaintiff's motion to compel response. Oh, that sounds pretty good. I'm going to boost it just a skosh. I'm going to boost it just a little bit. But that sound is actually pretty darn good. To plaintiff's third request for production. I can boost that more. To the defendants, Christopher Laundrie and Roberta Laundrie. That's DIN 124. We are also set for hearing today. Excuse me. All right, this is the court calling the case and telling you what's on the calendar for today. Standing here today is that we are noticed for plaintiff's motion to compel responses to plaintiff's third request for production of documents to the defendants, Christopher Laundrie and Roberta Laundrie. That's DIN 124. That's a discovery motion, financial records. Excuse me. For a defendant's motion for protective order and affidavit in support, and that is DIN 1. The protective order is the burn after reading letter that I'm very invested in. 104 and 105. And we are also set for hearing today on defendant Laundrie's motion to dismiss the second amended complaint, which is DIN 91, and defendant Bertolino's motion to dismiss the second amended complaint, DIN number 98.
Am I at all off on any of that?
No, Your Honor, that's everything.
Okay, so those motions to dismiss are coming up again. I'm actually surprised the judge has a fan too. I feel you, Your Honor. So we're going to hear these motions to dismiss today too. I wasn't sure if she was going to take oral arguments on those because Bertolino has not had a motion to dismiss. This is going to be a long hearing. That's a lot of motions.
Are there any others that we thought we were going to hear that are not, that I didn't list?
If there are, I'll be surprised.
Okay, great.
No, Your Honor.
Fantastic. Okay.
Four hearings
I'm going
today.
to ask you all's opinion on which we believe is best to be handled in what order.
I think the motions to dismiss should be heard first, Your Honor.
I would agree, Judge.
Okay.
Yeah, because
wonderful.
then if it gets dismissed, everything else is moot. So we're going to start with the motions to
Which
dismiss.
motion to dismiss do we wish to hear first?
Judge,
The
Mr.
Laundries.
Luke and I flipped a coin, so I will go first on behalf of Mr. Bertolino, if that's acceptable to everyone.
Okay. Bertolino's first.
Thank you.
Bertolino is the Laundrie's attorney. This is his motion to dismiss. I did not cover this in today's podcast because it was already an hour and 15 minutes long.
May it please the court.
Yes, sir.
Judge, once again, Chuck Meltz and Laura Kelly, on behalf of Mr. Bertolino, we're here today
I
on the
do have
motion
this
to
on
dismiss the
1.25.
Second Amendment complaint as it relates to Mr. Bertolino. Mr. Bertolino, as the court's aware, was added as a defendant in the Second Amendment complaint. The counts against him appear at counts 3 and 6. Although the counts are not labeled, it's clear from the history of this case and the nature of the allegations that the counts are premised on intentional infliction of emotional distress. And
Yes.
because of that, they derive from the restatement of tort,
Yes.
section 46,
I have it on my
which
bookshelf.
sets forth the various requirements for that count. Various Florida cases
These
have
are the
interpreted
elements
that, all of which
of the
we'll
crime.
discuss. Understanding we are here on a motion to dismiss, the way I plan to argue this is really to focus on the Second Amendment complaint, as the court must do. Understand that the court must accept the allegations of the Second Amendment complaint as pled. However, when we go through the Second Amendment complaint, I believe what we're going to be able to show is that those allegations fail as a matter of law and do not establish a cause of action for intentional infliction of emotional distress. We will also focus on the purported language that's at issue, Mr. Bertolino's comments as cited within the Second Amendment complaint,
This is a
which our
hard
position
case,
again is
Mr.
do not support a
Bertolino.
claim for intentional infliction of
This is
emotional
the
distress.
attorney for the attorney.
We'll talk about the different cases that have interpreted this particular cause of action, look at the illustrations that are in the restatement, all of which are informative as to what does and does not reach the level of intentional infliction of emotional distress.
Yes.
And our position at the end is going to be that the entire cause of action against Mr. Bertolino is due to be dismissed. And if for some reason the court doesn't get that far, there are certainly parts of the cause of action which clearly cannot be sustained, irrespective of any other argument set forth.
There are two causes of action to Stephen Bertolino, the attorney. This is separate from the Laundries. Bertolino was acting as their attorney, their agent. There is one cause of action for IIED from both Gabby Petito's father and mother. That's what he's talking about. Those are the only two causes of action here for him. I have this on 1.25 because otherwise attorneys talk slow. If it's too fast, chat, you can let me know.
I would also add, Your Honor, that we're mindful of the history of this case. And in making the argument today, we will absolutely cite to the cases that Judge Carroll cited to in his last ruling. The Liberty Mutual case in
different
particular
case.
is very informative, and also talk about some of the commentary from Judge Carroll that, again, previously dates our time in the case. So, Your Honor, just to start off, before we dive into the Second Amendment complaint, it's been around for a long time, but intentional infliction of emotional distress is a infrequently pled cause of action.
Correct.
It's a
It's
cause
hard.
of action that does not have a great track record in terms of what constitutes it or not. But what is abundantly clear from both the restatement and the cases that interpret it is that the threshold for bringing it is extraordinarily high.
This
And
is
so
a
as the
hard
restatement itself
case.
says, it's not been enough that the defendant has acted with an intent which is tortious or even criminal, or that he has acted to inflict emotional distress, or even that his conduct has been characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Liability has been found only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Generally, the case
I think in this case, a jury gets to decide. The court might disagree whether Bertolino's actions representing clients are outrageous in that way, or whether he is acting within his scope as a zealous advocate. And I think that's why this cause of action is very hard against Stephen Bertolino.
is one which the recitation of the facts to an average member of the community would arise his resentment against the actor and lead him to exclaim,
Well,
outrageous.
The community
So that
resents
is
the hell out
the
of the
threshold
Laundries.
for pleading intentional infliction of emotional distress.
That's happening.
So with that said, Judge, I would like to focus on the Second Amendment complaint And if you have our binder,
As you
it's
should.
tab C, which is where it appears. If you're looking at it electronically, I'm sure you have a way to pull it up. But let me know when you're there, and I'll move along.
This is not an easy case. It's not an easy case by any means.
I have it in front of me because I printed it, but I'm trying to find tab C here because it looks like your.
We have a small binder and a big binder. The big binder is the case law.
Why do you have
and
two
some other materials.
binders?
The small binder is the motions with the amended complaints.
Well, I like that. Okay, withdrawn. I like that there's two binders, and I like why there's two binders. A binder of the case law and a binder of the motions tabbed.
Your Honor,
Counsel,
the second amended complaint is a relatively
We love
short pleading
tabs.
that contains 6 counts. There are 2 distinct plaintiffs, Mr. Petito and Ms. Schmidt, and there are 3 distinct defendants, Mr. and Ms. Laundrie and Mr. Bertolino.
correct.
Mr. Bertolino is introduced in paragraph 7 and 8, where he's identified as a lawyer who's licensed to practice in the state of New York. And then in paragraph 8, that at all times relevant to within the cause of action, Mr. Bertolino was acting as an agent for Christopher Laundrie and Roberta Laundrie. So the first alleged fact within the 4 corners of the complaint is that my client, Mr. Bertolino, the purported actor in the intentional infliction of emotional distress, is in a unique capacity
we love
compared to
organization.
most who have come under this cause of action. He was an attorney providing legal advice and guidance and representing his clients. There's some additional information provided, Judge, but when we get to paragraph 20, this is where the background or the factual background starts to really come in. In paragraph 20, there's an allegation that on or about August 28, 2021, Brian Laundrie advised his parents,
This is why I'm on
Christopher Laundrie and
1.25.
Roberta Laundrie, that he had murdered Gabrielle
And we've
Petito.
covered this.
Again, it's an allegation in the complaint. Clearly, the plaintiffs can't have any firsthand knowledge of that. but they
Stephen
pled it. The
Bertolino
court's bound
is
by
an
it for
attorney in
purposes
New
of a
York. He
motion
was
to dismiss.
representing the Laundries. They all know each other.
It then goes on to say in paragraph 24, from August 27, 2021 until September 19, 2021, when Gabrielle Petito's remains were found at the
Yeah,
Spread
the
Creek
closed
dispersed
captioning is
camping
always
area in
unfortunate,
Wyoming,
but I think closed
plaintiffs were
captioning helps.
extremely distraught and were attempting to locate Gabrielle Petito.
They're going to argue.
And Your Honor, this is where
some of this they're going to argue that the outrageousness of this and the distress caused is the distress of Gabby Petito being missing, the distress of not knowing, not the distress of the Laundrie's actions. And I imagine that's where he's going next.
it's important to give our first real focus to what's in the Second Amendment complaint. Traditionally, causes of action for intentional infliction of emotional distress require the actor to trigger the emotional distress. The actor says harsh words. The actor threatens physical violence. The actor embarrasses or humiliates a target with intent and malice. In this case, Your Honor, by the own pleading, the plaintiffs allege that as of August 27, 2021, they were rightfully so and understandably extremely
Here it is.
distraught.
Here's that argument.
And that becomes important, Judge Brewer, because that level of distress predates any conduct of Mr. Bertolino in this case. So as a starting
He
point,
didn't
again,
cause
4
the
corners of the
distress.
complaint, the extreme emotional distress, which is the ultimate byproduct of where we head to, predates Mr. Bertolino's involvement. Paragraph 25 then talks about
I think
the
that's an
Laundrie
argument
family
for the
reportedly
jury.
going on a
I know.
family vacation.
This is going to make me
Paragraph
cry.
27, this is a reference to Mr. Bertolino, which really are few and far between in the Second Amendment complaint. It discusses that on September 13, 2021, Brian Laundrie left his home. Mr. Bertolino gave a press conference or interview a month or so later and described that he was grieving.
Yes.
I'm not sure that has a particular relevance to the case, but it's just one of the few paragraphs where Mr. Bertolino's statement or conduct
It
is
goes
actually
to
referenced.
show that he knew that
Where we get to paragraph
Gabby
28,
Petito was
this
dead.
is where
That's
the
why it's
first
there. Counsel, I could
purported
explain
fact
clapping.
setting forth the cause of action for intentional infliction of emotional distress against Mr. Bertolino is alleged. And it says on September 14, 2021, with full knowledge that Gabrielle Petito had been murdered by Brian Laundrie, and it is believed that they knew the whereabouts of her body, Stephen Bertolino, on behalf of Christopher Laundrie and Roberta Laundrie, issued the following statement. And so again, if we back up to paragraph 24, the emotional distress started on August 27th. Now in paragraph 28, we're at September 14, August 27th. This is the first purported act or conduct of Mr. Bertolino. Procedurally, Judge, paragraph 28 only contains a portion of Mr. Bertolino's statement that day.
It shouldn't
Based on
be the whole thing.
discussions with Mr. Riley, there's no objection to the entire statement coming in. It's
filed a
actually
stipulation.
Exhibit A to our motion to dismiss.
I saw the stipulation as to that.
Thank you, Your Honor. So I'll read the entire statement, understanding that there's only a portion of it in the Second Amendment complaint, but given the stipulation, it's all covered within the 4 corners at this time.
Understood.
So on September 14, 2021, Mr. Bertolino's office issues a statement, re Ms. Petito.
The Laundrie
It's a
family
statement
chose
for counsel
not to
from
be
the Laundrie
present in
family.
court.
This is an understandably,
lawyers are there.
understandably an extremely difficult time for both the Petito family and the Laundrie family. So let's look at that first sentence. There's no objective way. There's no context or circumstance. There's no interpretation that can be given to that, which would ever rise to the level of intentional infliction of emotional distress. The next paragraph. It is our understanding that a search has been organized for Ms. Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family. And again, Your Honor, there is no interpretation or anything else that you could apply to that statement which in any way makes it actionable under this particular cause of action. And then finally, it concludes, on the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. Before proceeding further, Judge, again,
That's the statement
sticking to what's
that
been pled
he's
here.
being sued for.
In every instance of intentional infliction of emotional distress, the actor has targeted the recipient. In every case that's cited, in every illustration, in the restatement, there's always been a target, for lack of a better term, when it comes to words. There are other examples of intentional infliction of emotional distress. Showing autopsy photos was one of the cases that Judge Carroll cited
awful.
too.
Awful case.
But other than that very rare exception, there's all direct
Intending.
communications. And the reason there's direct communications, Judge, is because the actor
targeted.
has to intend the emotional distress to occur. There's intent, there's malice, and then there's recklessness. But in either of those or all of those scenarios, it's linear.
This is a
The
recklessness
actor is doing
standard.
something ultimately targeted towards the recipient of the conduct. Here, again, just sticking to the Second Amendment complaint, what's been alleged
Just knowing it's false
is
is
that the
not enough.
Laundrie's attorney, Mr. Bertolino, acting in that capacity, put out a press statement to the general public at large. And no doubt an argument can be made that Ms. Schmidt and Mr. Petito
That was
had
my
access
fault.
to it or reviewed it or read it or heard it. But in terms of the intent, in terms of meeting that high standard of the restatement, which is so high that even criminal conduct doesn't satisfy it, we have a lawyer for a client who's issuing a public statement that in and of itself
But the intent was
is
to do his job as a
inactionable
lawyer. That's the
and
argument
totally
here.
appropriate. Again, what's within the four corners of the complaint. Paragraph 29, which now interprets that statement, alleges that for the Laundries and Stephen Bertolino to express their hope that Ms. Petito was located and reunited with their family at a time where they knew she had been murdered by Brian Laundrie was beyond outrageous. And again, that's an allegation. It's pled, and the court has to accept it, whether or not
Yes.
it's true. With that said, though, Judge,
I don't know why the
To
sound
express
keeps
hope.
shifting.
there is not an example in the restatement. There's not a case. There's not a commentary. There's not a law review article. There's not a single
This is a hard case as to
situation which has
Bertolino.
preceded us here
A
today
very
before
legally
you,
difficult
in which
case.
someone expressing a hope, let alone an attorney, let alone in a general sense and not even a direct communication.
The sound.
There's not a single case which suggests that expressing a hope, no matter what the circumstances, could be considered intentional infliction of emotional distress. Furthermore, Judge, as we know from paragraph 24, the emotional distress already occurred. And what's not
I'm going to pause here just because I've seen a lot of questions about assuming it's true. This attorney is arguing a motion to dismiss. The court has to take everything in the pleading for this hearing that the Petito family said as true. The court says everything on the face is assumed to be true. That's where they're arguing from. So this attorney's arguing, even if everything in the complaint is true, even if every inference is drawn to the benefit of Gabby Petito's parents, it still is legally insufficient. And it's a difficult, this part of this case is difficult for the Petitos. And this is where morality and legality are different, because how you may feel about this case and what the law says about this case are vastly different here. So that is where he's arguing legally, and he has a good legal argument. Morally is a whole separate thing.
in the complaint is that the statement of September 14, 2021 actually caused emotional distress. So when we think about the elements of the cause of action, we first have to have the statement or the conduct, then it has to legally cause severe emotional distress. Second Amendment complaint alleges that the plaintiffs, Ms. Schmidt and Mr. Petito, were already severely distressed. It describes the statement on September 14, 2021, and then it does not allege that it caused severe emotional distress. It discusses purported ill will by Mr. Bertolino in making the
Also
statement.
true.
Without facts, it attempts to paint it with malice. Without motive, it attempts to paint it as improper, but it doesn't actually link it to causing anything. Paragraph 30 and paragraph 31 talk about the dissemination of it. They're really jurisdictional in nature. I presume there was a concern that there might be a personal jurisdiction defense, which we did not raise, but that's really the thrust of those counts or those paragraphs. Same for paragraph 34, talks about activity within the state of Florida. Paragraph 35 is interesting, Judge, because
These are
paragraph
good
35
legal
talks about
arguments.
a letter
Argued well.
on behalf of Ms. Petito's family on September 16, 2021, not to my client, but according to the Second Amendment complaint to the Laundries, in which they are asking for information about their daughter. Paragraph 36, it talks about, despite the fact that Joseph Petito and Nicole Schmidt implored Christopher Laundrie and Roberta Laundrie to tell them if their daughter was alive, and if she was not, where her remains were located, Christopher Laundrie and Roberta Laundrie refused to respond to either Joseph Petito or Nicole Schmidt. Your Honor, again, Judge Carroll talked about that concept, the concept of inaction or not responding last time, although while it was in the body of his order, it didn't actually make it to the ruling, which we'll talk about in a second. But paragraph 36 is not actually directed to Mr. Bertolino, so there would be no obligation for Mr. Bertolino to respond to the letter, understanding there was no obligation of anyone to respond to the letter in the first place. Paragraph 37, while
He's
Joseph
talking
Petito and
legal
Nicole Schmidt were
or
desperately
obligation,
searching for
and there
information
isn't.
concerning their daughter, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino were keeping the whereabouts of Brian Laundrie secret, and it is believed they were making arrangements for him to leave the country. Again, no facts to support that. It's an allegation, true or untrue.
Doesn't
the court
matter. They
has
have to take it as true.
accept it.
Yes.
Paragraph 38, Ms. Petito's remains were discovered on September
Yes.
19. Also at that time, Judge, Mr. Bertolino issued another statement. The news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family. That's the second Bertolino statement described in the Second Amendment complaint. And before proceeding further with that, as the court knows from our motion to dismiss, Mr. Bertolino is being sued for offering hopes and prayers. And hope is definitely something you can't get sued for.
Not
And
malicious.
prayers certainly isn't. And again, as of September 19, 2021, a statement by Mr. Bertolino after the fact that the Laundrie family was praying for Gabby and her family definitionally cannot be actionable as a cause of action for intentional infliction of emotional distress. So now we're up to paragraph 39, and the court's basically heard virtually the entire factual predicate. Whatever facts existed, whatever facts were put into the universe to support these claims, we've covered them. And paragraph 39 then tries to tie in causation for the first time. So remember, we don't really have a causal
hard.
tie to the September 14th statement. There is no causal tie to the September 19th statement. But what paragraph 39 does is it essentially makes what I would call a refusal to disclose argument that's really separate and independent from the two statements I just read. Paragraph 39 says, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino knew of the mental suffering and anguish of Joseph Petito and Nicole Schmidt in not knowing the well-being or location of their daughter, and further knew that such mental suffering and anguish increased each day that Gabrielle Petito was missing. Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino further knew, and this is the key part, that they could prevent such additional mental suffering and anguish of Joseph Petito and Nicole Schmidt by disclosing what they knew about the well-being and location of the
Failure to
remains of
act
Gabrielle Petito, yet they repeatedly
Is
refused to
different.
do so.
Right. There's no duty there.
So we have
And
the
that's
actual
hard.
conduct by Mr. Bertolino. Again, both statements, not targeted, not specific to the family, general in nature, made on behalf of parents who themselves were in an extraordinarily difficult situation. Some of the case law talks about the mental stresses that are on the parties. Clearly, the Laundries had those mental stresses as well. But where the prior paragraphs talk about actions, paragraph 39 essentially says, Mr. Bertolino and the Laundries, Mr. Luca, I'm sure we'll discuss this. What we're suing you for is for not stopping the emotional distress, not causing it, but not stopping it.
It's a very good
We
argument.
started experiencing it much earlier in time, and you didn't stop it earlier by telling us
where she was.
the status of our daughter
Yeah.
and where her body was. And again,
It's a
Judge,
very
for
good
purposes of a motion to dismiss, whether or not any of this is factually correct, the
Assuming
court
it's
must accept it as true. So
the
that's what
law,
we're dealing with.
assuming it's true, it still doesn't.
There is no cause of action
Meet
for
the cause
intentional
of
infliction of
action.
emotional distress for not stopping it. There's a cause of action for causing it
That's a,
under
that's a
incredibly
really good
severe
argument.
and extreme circumstances, but there's no cause of action for not stopping it. And paragraph 39 is attempting to do just that. It's making allegations that because of inaction, not because of action, but because of inaction, the emotional distress that had been ongoing since August 27, 2021 wasn't stopped earlier. And Judge, with all due respect, that's just not a cause of action that's recognized under Florida law. It's not a cause of action that has passed grace by the Supreme Court or any of the appellate courts. It's not a cause of action that's described in Restatement Second. It's not a cause of action that's identified in any treatise or law review article that we came across, but that's the cause of action in this case. And the only time, by the way, Judge,
Yes.
where it alleges that anyone acted with
This
malice
is
or great indifference
just to Bertolino.
is
and
right
it's
after that.
a good
Right
argument.
after they refused to disclose. It says, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino acted with malice or great indifference to the rights of Joseph Petito and Nicole Schmidt. Not with the September 14th statement, not with the September 19th statement, but with this concept of not disclosing something that they purportedly knew. 1 through 39, Judge.
Oh,
that
did
is
you
all
hear
the
him?
alleged facts that this court has to work with.
Hold on. Did you hear Gabby Petito's father under his breath say they knew? Because this microphone is not muted and is picking it up, what he's saying at council table. Hold on. Let me move myself. I'm going to go back in just a second. Just a moment and see if we can pick that up again. Because he says they knew. Did you guys hear it?
Paragraph 40 then basically sets forth
I think
what
I
the
went
alleged
back far
wrongful
enough.
conduct is. To briefly
No,
jump
no,
ahead,
no, I
basically
didn't.
says that is all the alleged facts that this court has to work with. 1 through not disclosing something that they purportedly knew. 1 through 39, Judge, that is all the alleged facts that
That mic's going to pick up everything. Wow. All right. That's chilling.
this court has to work with. Paragraph 40 then basically sets forth what the alleged wrongful conduct is. To briefly jump ahead, when you go to count 3, which is against Mr. Bertolino, and you go to count 6, which is against Mr. Bertolino,
Yeah.
they consist of 2 paragraphs.
He did whisper it.
Basically, we incorporate paragraphs 1 through 40, and then Mr. Bertolino, as a direct and proximate result of the willfulness and maliciousness of Mr. Bertolino, and then they say caused damages. So again, the actual counts themselves, which don't have a title, which don't say they're for intentional infliction of emotional distress, which don't themselves identify what the purported wrongful conduct is within the counts. They're silent on that. So you have to go to paragraph 40 and piece paragraph 40 into counts 3 and 6. Paragraph 40 is a commingled count, which is obvious when we get to the A, B, C, D, E, and F part, because it essentially describes conduct for Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino as if all of them were acting in an identical manner. But nonetheless, what are the causes of action in this case, or what are the components that are alleged for intentional infliction of emotional distress? 40A, failing to advise the plaintiffs that Gabrielle Petito was deceased. So again, a failure to take action, a failure to disclose count. Again, as discussed by Judge Carroll in his order, there is no case law to support that. There's no argument that can be made to support that. Judge Carroll's comment was that if those were the only counts, the entire matter would have been dismissed. But yet in the order just said denied. And this is one of the difficulties with the way this case is pled. It really should be one count for each purported act of intentional infliction of emotional distress, because then that way the court could.
He's like, y'all Could you have pled this better? He's taking issue with the way it's pled. This case is strangely pled. This is a very difficult case against attorney Stephen Bertolino, and I think that's why they're just arguing the motion to dismiss and not arguing jurisdiction and all the rest of it, because they're just trying to get it yeeted, and they might. Bertolino might get dismissed out of this lawsuit, but he's saying, look, this is pled difficultly. It's pled to each, it's pled plaintiff to defendant, but it's not pled like this plaintiff to all these defendants for each statement, and it's hard. So I understand why he's arguing it. He's like, this could be easier, and they keep changing the pleadings, but the pleadings are difficult.
Determine as a gatekeeper, does this count stay or not? And then if for some reason it stayed for summary judgment purposes, we could say, well, count one, which is the failure to advise. Here's our motion on that. Because the actual counts don't describe the wrongful conduct, and because paragraph 40 just lists it as
Yeah,
an
but then
A
they'll
through
just
F,
amend it.
it does make
My
it
guy.
difficult to manage in terms of issuing orders
You're not
and
wrong.
approaching the pleadings.
You're not wrong.
But in any event, we're treating it as if A, B, C, D, E, and F are all individual or separate and distinct allegations of intentional infliction of emotional distress, because that's how they're described. But in any event, paragraph 40A, failure to advise. Paragraph 40B, failing to disclose to the plaintiffs the location of Gabrielle Petito's body. Again, another allegation of inaction, not an allegation of conduct that was intentional or directed, but simply inaction, discussed by Judge Carroll last time. Paragraph 40C, taking a family vacation. Clearly that can have nothing to do with Mr. Bertolino, but again, because of the way paragraph 40 is pled, it applies to him, even though obviously it can't. Paragraph 40D, blocking access to cell phones. Again, that one can't apply to Mr. Bertolino. 40E and F. This is the September 14 statement of hope in 40E. Paragraph 40F. This is the September 19 prayers after Ms. Petito's remains were discovered. And Judge, that is the entirety of the facts and the theories and the allegations.
Right, because there's
and the
nothing,
links.
there's
So
nothing
linking,
more there.
Allegations to conduct, linking conduct to causation, linking causation to damages, which is what's supposed to happen in the Second Amendment complaint. Those links are just not here.
This is the
And so,
third pleading in this
without
case.
going beyond the four corners of the complaint.
There's not enough.
On both
is
sides,
what he's
because
arguing.
obviously Mr. Riley can't stand up and fill in the blanks. They're either in the Second Amendment complaint or they're not. Based on what's in the Second Amendment complaint, and more importantly, based on what's not
He's
in
like,
the Second
there's
Amendment
nothing you
complaint,
can do on this.
the Second Amendment complaint against Mr. Bertolino can't stand. Turning to the law, Judge.
The closed captioning is getting it not right at all. This is
The
not
case law
about
is clear
handstands.
that the court, the court serves a gatekeeper function when it comes to intentional infliction of emotional distress. In the Liberty Mutual case,
Kara, we're not there yet. We're still,
And Your Honor, this
they're still
is
doing the
in our
motions to
case law
dismiss. This is
binder,
going to be a long hearing today.
566, but this is a case that Judge Carroll cited quite a bit in his order. It's Liberty Mutual versus Stedman. The site is 968 Southern 2nd, 592. It's a Second District Court of Appeals case from 2007. This talks about whether or not a complaint can state a cause of action for intentional infliction of emotional distress. In this case, as every other that interprets it, identifies that threshold as a question of law for the court. So oftentimes we find ourselves at motions to dismiss.
What he's saying to the court when they're citing this case is critical. This is a matter of law. The court has to decide as a matter of law if this conduct as pled, all taken as true, even states a cause of action. And the argument here as to this lawyer is it doesn't. And it's going to take a lot for the Petito's attorney to move my brain legally, because it seems that he's right in these arguments. And this, again, this is a difficult case, pled in a novel way that we don't often see. The motion to dismiss has survived multiple times as to the Petitos, as to the Laundries, but not as to Bertolino. This is a hard one.
Dismiss, where the court asks me, Mr. Meltz, isn't that more of a summary judgment argument? Isn't it factual? Whether or not a complaint sets forth a cause of action for intentional infliction of emotional distress is a question of law. So it's clear from the case law that, Your Honor, at this somewhat early phase in the litigation, has the legal authority and the legal requirement to make that determination. It's not for a jury to make at a later day. And it's also something that no deposition or discovery is going to affect because, again, we have to look at the four corners of the complaint and determine, does it meet this standard? And as the court in the Liberty Mutual versus Stedman case discussed, behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That's the standard. So we have to take that standard
The
and we have to
legal
look at what's
standard,
alleged in the Second
not the
Amendment
moral
complaint
standard.
and see
Because
if
on
it
the
meets that
moral
standard.
standard, you're like, I get
In
it.
applying that standard, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. Rather, the court must evaluate the conduct as objectively as is possible to determine whether it is, quote, atrocious and utterly intolerable in a civilized community, whether conduct is outrageous enough to support a claim of intentional infliction of emotional distress is a question of law, not a question of fact. So, Your Honor, you have the task and the burden of reviewing the language and the paragraphs that we just read through and determine whether Mr. Bertolino offering hope on September 14th and offering prayers on September 19th on behalf of his clients as their attorney, as their agent, in a general sense, non-targeted, with no reason, motive, or any other factor to make these mean-spirited in any way, but you have to determine whether those allegations rise to that level of utterly intolerable in a civilized community. And again, Judge, hopes and prayers can't rise to that level. And the allegations that there was a duty to be
False
silent,
hope
to
is
disclose, that there
not
was a
going
duty
to reach
to make
this level,
plaintiffs aware of whether or not Ms. Petito was alive,
And there
who she was, and
isn't.
where her body was.
which sucks.
That's just not
but
a
there
duty that
isn't.
exists under the law.
It does
and it's not a
not.
cause of action that exists under the law.
It's-
And again,
It's cruel.
Judge Carroll incorporated that
But
in
it's
his
not-
last ruling, and there's no case law to suggest anything to the contrary. We've cited other cases, Judge. They all say the same thing. It's a tremendous burden to show truly horrific conduct. That burden has not remotely been met here, yet alone tied into legally causing actual severe emotional distress or damages.
And
Separate
this
and
is
apart from
all
that, Judge,
in
and
their
I'm
written
winding
arguments as
down.
well.
Despite the fact that it's not properly alleged and can never be, and despite the fact that the law creates a burden that the plaintiffs can't hurdle, we also point out, as set forth in the restatement and various other cases, that separate and apart from those issues, even if the court were to find that this conduct was utterly atrocious,
This is the arguendo.
an attorney
Even
who was
if-
functioning as Mr. Bertolino did, who is representing the Laundries, who themselves are unwittingly and unasked for part of a horrific situation in which all of the events are ongoing as they were.
He's acting as a
It is
zealous
legally
advocate.
permissible for Mr. Bertolino, as the Laundrie's attorney,
Yep.
to make statements like the ones that he did. And the restatement of torts is clear that when an actor acts in a legally permissible way, there cannot be intentional infliction of emotional distress. They give examples of a landlord who knows a family's sick, but they didn't pay their rent, so they're evicted. The landlord clearly knows that putting them out on the street would cause intentional infliction of emotional distress, but they were legally entitled to do so. In the various insurance company cases where the insurance company would ask about whether someone qualified for Medicare or whether they met certain conditions, even though there may have been a denial or delay in treatment, they couldn't be held responsible because they were legally permitted to do so. To suggest that Mr. Bertolino, as the Laundrie's attorney, wasn't legally permitted to make a statement to the general public of a hope and a prayer in an extraordinarily difficult circumstance would to suggest that any lawyer
That lawyers can't
acting in that
advocate
type
for
of
their
circumstance
clients, ever. in
would
any
be at risk
circumstance.
for unintentionally causing emotional distress or unintentionally offending someone or unintentionally causing someone
Lawyers offend people all the
with
time.
feelings of grief. There's no way to navigate that situation.
Lawyers cause distress.
You have two families who are going through something no one can prepare for, something that no one should prepare for or ever expect. But both families have their own issues, and the Laundries needed Mr. Bertolino. Mr. Bertolino acted as their attorney, and as the Second Amendment complaint says, at all times he was acting as their agent, and as such, he was legally permitted
he's allowed to
make
do
the
so.
statements that he made,
Yep.
which themselves are not actionable. Finally, Judge, I do note that Judge Carroll
That's
addressed
previous judge.
the statements at issue, not really the September 19th statement, but the September 14th statement, where he talked about context. I would note, though, that Judge Carroll did not talk about context with Mr. Bertolino as a party, as a defendant. And also, Judge Carroll's discussion about context didn't factor in all of the other elements, such as causation, such as intent, such as recklessness. He simply addressed what was pled and filled in the context.
Right.
With that said, though, Judge, the full statement creates a much bigger context, which Judge Carroll did not have the benefit of last time, which I think contextually makes the statement much more understandable and benign. And then secondly, while Judge Carroll discussed the Stedman Liberty Mutual case, he didn't talk about that part where it said, in applying the standard, the subjective response of the person who is the target of the actor's conduct does not control the question. Nor did he address that the plaintiffs
Very
weren't the
good
target,
point.
because again, the statement itself was
Was to the
publicly
public.
disseminated.
It was not to them. It's also a good point.
It's an emotional case. The issues are complex.
That's why they want the judge to
There's
hear
no
it
bright line
first.
rule. It's very doubtful we'll ever see this exact fact pattern again. But none of that changes that the Second Amendment complaint still has to set forth a recognizable cause of action, and it doesn't. And it's just white or black.
You
Judge.
could just
And so,
hear-
With that said,
You could just hear Gabby Petito's mother say, "Oh my God," on their mic. And I can understand why, but legally his arguments are good. They are legally sound and they are well made.
the court needs to dismiss it.
And they
At a
might.
minimum, if the court
This might
doesn't
get
dismiss
dismissed.
it, then clearly those parts that need to be dismissed need to be dismissed.
Yeah.
Those parts being the failure to disclose, the failure to act, the failure to
very
speak,
real
none of
possibility
which is
here.
supported by law. So our position would be the entire Second Amendment complaint, or rather the counts against Mr. Bertolino, but I'm sure Mr. Luca will have a similar argument. But the Second Amendment complaint against Mr. Bertolino needs to be dismissed.
I mean, he's
in its
restated
entirety.
his entire written
If not,
motion.
it certainly needs to be
He's
pared
done it
down.
well, but I'm like, okay.
And as to prejudice, Judge, I would note that we are on the Second Amendment complaint. There's
Yeah.
been 2 prior amendments. This is the third
Oh.
opportunity to set forth the cause of action.
He's talking about prejudice, not in the way that you think. He's talking about whether or not this will be dismissed with or without prejudice. I just want to pause to let you know what that means, because the way that we think of it in common vernacular and the way that it's meant here are 2 totally different things. What he's arguing is, will the Petito parents be allowed to amend again? This is their 3rd crack at it. So will they get a 3rd amended complaint, which is really a 4th complaint? So will it get dismissed, and will it get dismissed with or without prejudice? With prejudice means you cannot file it again. You cannot try to fix it. It is done. Without prejudice means you can amend it again. This is the first complaint that is looped in Bertolino. So the court might allow it to be amended. However, we saw this in other cases that I've covered, is when the court says everything is on the table and that's still not enough, then they might not allow this to be amended. So if this is dismissed, and if it is dismissed with prejudice, Bertolino cannot be sued over this again. Hopefully that makes it clear.
Action. The framework to the count was clearly argued last time. Judge Carroll's order was instructive. The case law has been at issue. Presumably, if there were better allegations that could be met against Mr. Bertolino, they would be in the Second Amendment complaint, and they're
That's
not.
a fair
So
point.
based upon that, our position is the Second Amendment complaint against Mr. Bertolino should be dismissed,
With prejudice.
and given the procedural history in the case, should be dismissed with prejudice.
Okay.
Thank you.
All right, thank you so much, sir. Mr. Riley, did
You could
wanna let
hear-
Mr. go and you respond to both of them, or did you want?
You could hear Gabby Petito's mother again say, "Oh my God." If you have headphones in, you might be able to pick this up better, but you're getting those kind of moments because their microphone is on. The court's asking the attorney if they want to respond to one at a time or both at once.
To
I say both
go
at once,
now
but
and then-
Since their arguments are basically the same, I'm fine with Mr. Luca going now.
Yeah, that's what I would do too.
Thank you, Your Honor.
This is the
please the
attorney
court?
taking the stand for the Laundrie.
Your Honor, I will try not to replow the same ground as Mr. Meltz, but I'm sure I will. So I just want to apologize in advance.
I love that turn of phrase. I do that all the time. I'm going to try not to replow the same ground. Counsel, I appreciate that.
So, Your Honor, in the
Oh, did she
plaintiff's
say thank
response
God?
to our
She might have.
motion, they assert that we are simply trying to overrule Judge
Thank God they're
Carroll's
done.
order. Now, while we are asking the court to dismiss the action, which Judge Carroll did not do, our arguments in this motion are, for the most part, issues Judge Carroll did not consider. Most specifically, as Mr. Meltz pointed out, his client wasn't a defendant at that time. But there are other issues for my clients as well. At the first motion to dismiss hearing,
Brian Laundrie's parents have lost their motions to dismiss twice already. They are situated differently than Stephen Bertolino.
the plaintiff's theory, at least as we interpreted it, was that the Laundries caused them emotional distress by failing to communicate about Brian and Gabby, specifically to disclose Gabby's whereabouts. And that theme is repeated again in the Second Amendment complaint and also in their response to our motion to dismiss. So our primary focus at that first hearing was that the Laundries had a number of constitutional and other legal rights that protected their communications and activities, and thus they had no duty or obligation to act in a certain way or to communicate information.
You've made this argument already.
Now, Judge Carroll did agree that the bulk of the plaintiff's allegations did not support the cause of action because the defendants had no duty to speak under the circumstances. Now, I don't know if the court wants me to re-argue.
And they don't. I know that this is a point of contention. I know that a lot of you disagree. I understand the moral disagreement, but the Laundries did not have an affirmative duty to say anything at all about where Gabby Petito was. So that's what he's arguing. And that is where legality and morality get difficult to parse, especially when you have all the feels. It feels horrific and cruel and gross, but legal and moral are different, very different. A lot of people struggle with that the first year of law school. Some don't. And when they look at lawyers and they're like, why are you all so callous? It's like, well, we've spent an entire legal education being like, morality over here, legality is what we argue. And so lawyers can come across as not addressing the emotions of a thing. These lawyers, I think, have done a very good job of addressing the emotions of the thing while then arguing legally well.
Those points, or if you would prefer that I just pick up from where Judge Carroll's findings.
Pick up where he left off.
In the past, and I've briefed them again this morning.
The court's like, I've read all this shit 5
It's your
times.
case to argue. So.
Absolutely. Thank you, Your Honor. And if you do have any questions about
Thank
what
you,
we
Your
argued at that
Honor.
point, how Judge Carroll came to that, I'm happy to
I
answer.
would be happy to ask.
So
The court's
at
like,
the first hearing on the motion to dismiss, Mr. Bertolino's statement at that time was really just one
He's
of many
very loud.
allegations. And admittedly, we didn't focus on it in our argument, probably as much as we should have. However, Judge Carroll found that of all the allegations, because Mr. Bertolino's statement was an affirmative act, which, although in isolation did not rise to the level of outrageous conduct, that it's possible the plaintiffs could develop some context for it that could render it outrageous. Like I said, we didn't concentrate as
They're
much
bringing up the other
attention on the
judge's
statement as the
ruling
first
because
hearing
it's
as we should have.
controlling here.
And knowing now that it was the critical allegation in the case, we should have focused our arguments on that topic, so that's what I'll do now. In that regard, we're not asking the court to overrule Judge Carroll because Judge Carroll did not have the benefits of a lot of the arguments we're going to assert today. First, Judge Carroll did not have the benefit of Mr.
You've already made these arguments twice. You've lost twice. This is their third motion to dismiss.
Bertolino's entire statement. Plaintiffs only included the one paragraph out of the 3 paragraphs in the original complaint and also in the Second Amendment complaint. And as Mr. Meltz said, by stipulation, the
added
court can
more.
consider all of those paragraphs for purposes of this hearing. Second, Mr. Bertolino's statements were legally protected both by the privilege afforded to the exercise of permissible conduct when it comes to a cause of action for intentional infliction of emotional distress, and also the litigation privilege. Third, whether the statement alone, as opposed to the other allegations that Judge Carroll found did not support the cause of action, was either produced or substantially contributed to producing the severe emotional distress. Fourth, whether Mr. Bertolino's public statement, again, as opposed to the other allegations, satisfies the requirement that it be directed at the plaintiffs and in their presence. And lastly, the addition of the allegations against Mr. Bertolino renders the allegations against the Laundries implausible. So first, Your Honor, Mr. Bertolino's statement is not outrageous. And Mr. Meltz read the statement. I won't read it, but I will talk about it.
The reason the Laundrie's attorney is arguing about Bertolino's statement is because it's being attributed to them as the only affirmative, well, as one of the affirmative acts here, blocking on the phone, blocking on Facebook, these statements. That's why he's arguing what the lawyer said, because what the lawyer said as an agent of the Laundries is being attributed to them, kind of the reverse of Johnny Depp being attributed the lawyer's statement. Well, no, it's the same. The lawyer's statement's still being attributed to the client, not the reverse. Same. So that's why he's talking about Bertolino's statement.
Whether the conduct is outrageous is a matter of law for the court to decide. And the plaintiff's subjective reaction to the conduct does not control. The statement itself must be objectively outrageous.
They have a much better chance
Generally,
of
an
getting the
outrageous
judge
act
to
is
eat
one
this
in which the recitation of
than
the
a
facts to an
jury.
average member of the community would
Much
arouse
better.
his resentment against the actor and lead him to exclaim, outrageous. If I recited Mr. Bertolino's statement to the average member of the community, their reaction would not be to exclaim, outrageous. They would probably think it sounds like a statement they have heard many times before
Sir, don't ask the internet.
by an attorney in a public comment about a case. Basically, a statement that says nothing of substance and is an attorney just trying to say something favorable for one of his clients. In paragraph 39, which is on page 19 of the plaintiff's response to our motion, they acknowledge that the statements, and when I say statements, I mean the September 14th statement and the September 19th statement, without context, seem to be an appropriate expression of sympathy and understanding
Kara, I've
for
not
the
seen
trauma
any
which the Petito
defamation
family
here.
was undergoing.
No.
Had they been said by anyone else but the Laundries or Bertolino, they would be interpreted as genuine and sincere. So basically what the plaintiffs are saying is the statements are not outrageous, but the plaintiffs did not interpret them as genuine and sincere, and thus it caused them distress. So going back to the standard,
It's an
Your Honor,
interesting argument.
objectively, the statement is not outrageous, but subjectively, the plaintiffs interpreted it as such. That's not the standard for liability. The subjective interpretation of the plaintiffs does not control. It is an objective standard, and by objective measure, the plaintiffs even acknowledge that the statements are not outrageous.
Is it objective just taking the
Good question from the court.
statement as it is without any context, or is it the objective person sitting in the same exact contextual position
Correct,
as
Your Honor.
the plaintiffs?
That's an interesting question, Your Honor, because the way that the case law frames it is an outrageous.
My interpretation is that is the court saying to counsel, the way you're arguing in that is not the way I'm interpreting that. So can you bridge the gap there a little bit? Because the way you're arguing that standard is not how this judge interprets that standard. So he now has to answer that question for the court. The court is like, is it though?
This act is one in which the recitation of the facts to an average member of the community. So I would submit that the standard takes into account what an average person would think within the community, not necessarily the plaintiff in that position considering whatever the conduct is that's alleged to be outrageous. Now, I don't have a specific case that discusses exactly how the court would consider that issue.
Question, because that's what I said. You said that, but has any court said that?
Yeah.
Your Honor, other than the quote that the outrageous act is
No,
one in which
Your
the
Honor, the
recitation
answer
of
is
the
no.
facts to an average member of the
He's
community.
going to
That is a
replow it.
citation.
Okay. You probably already said it, but just in case I.
Hang on, let me pull that up, Your Honor.
Your Honor, let me pull up the case facts. So, are they blocking the judge's face? No, it's just the
Guessing off
position of
top
the
my head that
cameras.
It's probably the Metropolitan case, but I will double check that.
If it is the crux of your argument, it is helpful to know. Because the court's like, no, show me where it says that, which I appreciate. The court's slowing it down to ask. So I love that. For
So
the
it's
court.
Eastern Airlines Incorporated versus King, and the site for that is 557 Southern 2nd, 574, page specifically
site.
576. And that's a Florida Supreme Court case from 1990.
Okay, thank you.
Oh, let me change the pinned comment. This is the lawyer
Your Honor, I would
for
also,
Laundries.
In addition, again, citing the Metropolitan Life Insurance Company versus McCarson, the site for that is 467 Southern 2nd, 277. And that's, again, a Florida Supreme Court case, and it's from 1985.
467.
467 Southern 2nd, 277,
Okay, perfect.
specifically page 278.
Thank you.
And again, that's the case that essentially adopted the cause of action for intentional infliction of emotional distress in Florida. And in that case, Your Honor, again, one of the standards that the court has to consider is the court must evaluate the conduct as objectively as possible to determine whether it is atrocious and utterly intolerable in a civilized community. Again, Your Honor, sort of referencing that the standard involves what a person within the community would think of it, not necessarily how a specific person in the specific position of the specific plaintiff might consider that particular conduct.
Objective versus subjective belief is a big, big deal
But Your Honor,
here.
if you'd like, I can do some research after the hearing and submit a supplemental to the motion to try
That's
to
okay.
pinpoint that issue.
I can probably do it myself. That's the question that,
Objective, subjective is a big deal.
it appears to me that Judge Carroll has already answered that question from a motion to
Right.
dismiss standpoint, though. That's where I'm having some trouble with your argument. And I understand that you're saying, well, now we have the full statement. But you're saying that the full statement changes the context in which the middle part should be read.
Yes, Your Honor, that is my position.
All right.
Okay. And she's
Because
like,
I'll get to that, but
no.
essentially my position is that taking that middle paragraph in isolation, without the two paragraphs that both precede and follow it, because those two, the first and the third paragraph really do provide the context for why the plaintiffs wouldn't necessarily regard that statement as what they claim it to be. In other words, the explanation that Mr. Bertolino offers sort of puts it in the position of, hey, we know this statement might not be enough, but based on the advice of our attorney, it's all we can say. That's what the last paragraph of the statement says, which is important for our purposes, because really what the plaintiffs are saying is you should have said more. And that's really what Judge Carroll said too, is there could be context where perhaps they should have said more in the statement, or the statement should have been worded differently, whatever it might be, considering the context of that last paragraph.
Bertolino's a
It's
defendant
informing
here.
the plaintiffs.
He's also not
I'm
licensed
sorry
in
that this
Florida.
statement may not be to your liking, but based on the advice of our attorney, this is all that can be said. So that's our position. And Judge Carroll didn't consider that position at all, because the full statement was not in the record at that time. We didn't argue those other paragraphs at all.
okay.
And Your Honor, we believe that this is a fundamental flaw in the plaintiff's cause of action, is that it is based on their subjective interpretations and general cynicism for anything the Laundries did. For example, they claim that the Laundries' visit to Fort DeSoto Park was outrageous. And they claim that Mr. Bertolino's September 19th statement, in which he offers condolence and prayers for Ms. Petito's death, that's outrageous. That's a subjective assessment. I mean, I don't know that there's any reasonable person that would objectively think somebody going to a park would be outrageous.
Don't ask the internet. The internet was outraged that they went camping with their son while Gabby Petito was dead and her family was still looking for her. The internet finds it outrageous, sir. I know that you're going to argue that polite society does not, but it feels kind of gross. So that's okay. And no, the Laundries are not in court.
Your Honor,
They've not been in court.
I really think that, I know the plaintiffs allege a lot within their complaint, maybe not as much as they should to meet this cause of action, but the statement by the
internet is
plaintiff's
outraged.
attorney that's alleged in paragraph 35 of the second
So there's that.
amended complaint, and plaintiff's response to the motion, really when it's boiled down to the essence, what they really complain about is that the Laundries did not disclose Gabby's whereabouts. That seems to be the information that they really...
This is why the circumstances matter.
That's really at the heart of their complaint. But what's interesting about the complaint is that they don't actually allege that the Laundries ever knew Gabby's whereabouts. As Mr. Melt said, it's insufficient for them to plead opinions, theories, legal conclusions, or argument.
That just
the court
froze.
does not have to accept those as true for purposes of deciding
That
the motion.
froze in a very unfortunate way.
The only allegation of any substance that the Laundries knew anything is
Oh,
in
gosh.
paragraph 20 of the second amended complaint. And there it says, it is believed and therefore averred that on or about August 28th, 2021, Brian Laundrie advised his parents, Christopher and Roberta Laundrie, that he had murdered
The
Gabrielle
Petitos are
Petito.
outraged now.
They do not ever allege that Brian
Look at
told
them.
his parents Gabby's location or any other details. And other than that one allegation, they don't allege any other conversations with Brian. They don't allege any conversations with Mr. Bertolino or some other source where they may have learned that information. They don't allege how, if the Laundries had that information, how they would have come to know.
The letter.
For that reason, Your Honor, with respect to that issue, there are no allegations in the complaint other than conclusions or theories that the Laundries knew Gabby's whereabouts.
It is conclusory a lot.
And so if the plaintiffs don't even allege that the Laundries knew that fact, their cause of action can't be based on a failure to disclose it.
The Laundries want to get
Now,
up and
plaintiffs may
argue
try
this
to
for
argue
themselves.
The
and they
Laundrie's
can't.
knowledge can be inferred
They have to
from their
rely on
other
their lawyer.
allegations. Your Honor, I would submit that that's not a reasonable inference. Again, first of all, they don't allege any other conversations with Brian Laundrie other than that one conversation. Second, as we know now, and as alleged in the complaint, Ms. Petito was found in a remote part of a national park in Wyoming. It's not a reasonable inference to assume that the Laundries would have known that location, or that they could have even found out where that was. Your Honor, intent is also a critical factor here, and one in which the plaintiffs offer no concrete allegations other than conclusions. I'll discuss intent again when addressing the plausibility of the allegations against the Laundries.
Petitos
But
need to have
juxtaposing
a
the intent
notepad
required
so they can
in order
write
to commit this
what they are
tort
thinking.
with the words of Mr. Bertolino's statement and
just-
the other allegations of the complaint, there simply isn't outrageous conduct. The standard is, with regard to intent, that it's not enough that the defendant act with an intent which is even tortious or criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. And again, Your Honor, this is the Eastern Airlines case that I cited earlier.
Okay.
Rather, liability is established only where the alleged conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Now, Your Honor, I did touch on our argument with regard to the paragraphs earlier, but I'll
No.
go through it in a little bit more
The
detail here.
Laundries are not obligated to be in court at all.
So the
Their
first
lawyers
paragraph
are
of
there,
Mr.
and this
Bertolino's
is a civil
statement
case.
acknowledges the difficulty of the situation for both families, which is important. It acknowledges that it acknowledges what the plaintiffs were going through and the struggle that the Laundries were also balancing. Certainly a situation that neither family expected to be in and one that was full of challenges for everyone involved.
But if the
Now,
letter
you
was
couple
written
that
in
with the third
advance, I got
paragraph,
questions
which
about that
basically
too,
says,
sir.
I'm sorry, I know you would like us to say more, but we cannot on the advice of our attorney. We are going to stay in the back. The statement conveys, we understand how hard this is for you, but our son is in trouble, and we have to rely on the advice of our attorney in this extremely difficult circumstance. Far from being outrageous, that is exactly what most people in that situation would be thinking and doing. Those two paragraphs are critical because they run contrary to the plaintiff's conclusory allegation that the Laundries acted with malice and ill will. To the extent the Laundries withheld information with some sinister intent, which I'm not saying they did, that is facially disproved by Mr. Bertolino's statement that the Laundries will not provide additional comment based on the advice of counsel. Now, the plaintiffs want to focus on the middle paragraph, which is probably why they omitted the other two paragraphs from the complaint. Now, the first sentence of the middle paragraph says that a search was organized in Wyoming. A factually accurate statement. I don't think anybody is disputing that.
Is
The
outraged by
second
that?
sentence, which says, we hope the search is successful and Ms. Petito is reunited with her family. Now, the plaintiffs claim that that sentence caused them distress because it made it seem as though Ms. Petito could still be alive. Now, on its face, the statement does not indicate that Ms. Petito was or was not alive. It is an
They're gonna. I don't want to be the attorney that has to argue. This could just mean her remains. I would never want to be in this position, ever. But that's where this is going.
ambiguous general expression of hope. And we've cited a number of sources in our brief where the term reunited is used to describe when a deceased person's remains are returned to family members. That's
It's like I know things.
a term used by the National Institutes of Health, the Reuniting Families Project, the United States Army, and a number of news
It
organizations.
feels.
Now, the plaintiffs dismiss this fact, but again, the
So
plaintiff's
heavy.
subjective interpretation of the statement is not what controls. It's the objective interpretation. And those sources that I cited, government agencies and other news organizations, would use that word to describe when a deceased person's remains are returned to their family.
And there's a reasonable argument there. It's
So you're saying
hard.
from an objective standpoint, a reasonable, prudent person, if they are told, we hope that
Good
Ms. Petito is
question.
reunited with her family, that the reasonable, prudent person would believe that to objectively mean that her remains would be reunited
The judge is
Really
not
what
buying
I'm
in all instances?
I'm not saying,
Sir.
yeah, I'm not saying in all
Sir,
instances, in all
the
contexts.
judge
Really
is
what I'm
not
saying
buying
is that
that in
the
this
statement is
context.
ambiguous. And so somebody reading that statement
I'm backing up. Something just got said at the Petito table, but he's talking so loud. Me all the time, but he's talking so loud it was hard to hear exactly what was said. But the court is like, sir, really? Oh, this is going to be interesting.
Reunited
really what I'm
in all instances?
I'm not saying,
Context?
yeah, I'm not saying in all instances, in all contexts. Really what I'm saying
judge's
is that
face.
the statement is ambiguous. And so somebody reading that statement would not necessarily immediately jump to the
I heard an
conclusion
F-bomb.
she must be alive.
Okay.
And Your Honor, with respect to the plaintiff's assertion
just
that
lost
they
the
interpreted
judge a
Mr.
little.
Bertolino's statement to give false hope that Ms. Petito was alive, it's contradicted by the allegations of the Second Amendment complaint. So Mr. Bertolino made his statement on September 14th, 2021. And then 2 days later, the attorney
Yeah.
for the Petito family, Richard Safford from New York, issued a statement to the Laundries, and it's found at paragraph 35.
Oh,
of
yes,
the
they're
Second Amendment
arguing.
complaint. And I
The
won't read
way
the whole
they're
statement, but
arguing indicates
specifically,
the way they're arguing indicates that when the statement was made, they knew she was dead. But the judge is not all the way with him on this one. Notice the judge did not ask questions of the other attorney at all. These are two very different motions to dismiss, and the judge is not with him. He is arguing in these circumstances, someone hearing the word reunited would think it was remains, not someone found alive. And the judge is like, okay. So this is why I said in today's podcast, lawyers, you have to pick your civil cases carefully because you might not want to be the one standing up in court having to make this argument whether or not the word reunited means with someone who is found alive or their remains, because a lot of lawyers don't want to be standing up there making that argument.
within that statement, Mr. Safford says, "We believe you know the location of where Brian left Gabby." And then later the statement says, "How can you keep her location hidden? Please, if you have any decency left, please tell us where Gabby is located."
And clearly,
Now, the attorney asked 3 times in that statement about Ms. Petito's location, but not once did he ask for clarification about whether or not Ms. Petito was alive.
oh my God.
Clearly, at the time,
Yeah,
the plaintiffs and their
same,
attorney did not believe
same.
that Mr. Bertolino's statement meant that Ms. Petito was still alive.
His face says you got to be fucking
I
kidding
think it's
me.
also important to note that this statement by the plaintiff's attorney focuses on Ms. Petito's location as the information that the plaintiff
Bitch,
saw.
I don't wanna be
But as
making this
mentioned
argument
previously,
in
there are
court.
no actual allegations as opposed to opinions or conclusions that the Laundries knew anything about Ms. Petito's location that they could disclose. Again, paragraph 20 only alleges that Brian informed his parents that he had murdered Ms. Petito, not the location.
I'm sorry, but I just need to say for a minute, this is giving, I'm going to compare this case to Vanderpump Rules. This is a civil case. I know the circumstances are awful. However, this is giving, if Ariana had just stalked me, she would have seen I wasn't going to Schwartz's house. It's like, well, if they had asked more specifically, they begged the Laundries for information regarding Gabby Petito. You know that they did. So saying, well, they didn't specifically ask is splitting hairs in a way that is not going to help. Look, the other attorney, you are getting to see 2 different types of arguments, right? The other attorney, we sat here and went, that is a good point. Yes, that's legal. Yes, I get where you're coming from. This attorney, we have now walked into the realms of, are you fucking kidding me that you just argued that? Whoo, okay. Look, he is trying to argue for his client. This lawyer is doing his job. You are welcome to not like his arguments. Fred doesn't like his arguments. Did you hear that cat complain? This is zealous advocacy. This just feels awful. And you can see it on the Petito's faces. You can see it on Gabby's parents' faces.
And in that same statement, Your Honor, by the plaintiff's attorney, he acknowledges the complicated situation faced by the Laundries. He says, "We understand you are going through a difficult time, and your instinct to protect your son is strong." Again, Your Honor, conveying that they understood why the plaintiffs maybe couldn't say more. They recognized the situation, the difficult situation that everybody faced. So again, that statement suggests that they were not
You have to say hi first.
insulted by their statement. They were not caused distress necessarily by the statement. They understood why the statement said what it did and why it didn't say other certain things.
I don't know if that's how I would interpret that.
Your Honor, if we compared the plaintiff's attorney's statement with Mr. Bertolino's statement, I don't think that we would say that the plaintiff's attorney's statement was tortious. The plaintiff's attorney expresses understanding for the Laundries' unenviable position, just like Mr. Bertolino did. And then, questions whether the Laundries had any decency left and things like that. And arguably, Your Honor, this statement was a violation of the rules of professional conduct because it was an attorney directly contacting a party who he
What?
knows to be represented by another.
Sir, what did you just do? What did you, Fred? Oh, sorry, buddy. What? He's arguing that the statement by first he argues they didn't ask the right questions, and now he's arguing and the asking of the questions is actually a breach of the rules of professional conduct. See, Bertolino's attorney showed us the realm of making a difficult argument in a sensitive case well. Bertolino's attorney walked that line of this is difficult, but these are my legal arguments. This attorney has just jumped into a puddle full of shit and is splashing around in it, and this is not going to be a good look. Oh boy.
Attorney
Oh,
as opposed
oh,
to going
boy.
through that person's attorney. But regardless, Your Honor, the point is we could parse
Holy
every public
shit.
statement that an attorney makes and raise a cause of action for intentional infliction of demotion.
You didn't have to go there, bud.
In this case,
You,
this statement is not outrageous by Mr. Safford, and neither is Mr. Bertolino's statement. They're just public statements by attorneys during a very, very difficult situation for both families. Now, ultimately, the court has to decide whether Mr. Bertolino's statement.
chat, I grant your motion. Motion granted, motion granted. I can't believe we ended up with, well, actually, this statement was actually a violation of attorney rules of professional conduct. Sir, you have taken a grumpy on your argument. For those of you that are new here, hi, go ahead and subscribe. I'm Emily. This is a flash warning because this is a little flashy, but I love it. At the end of the music, the flash ends. We're going to code red because code red is our what the fuck level of fuckery. And so I think that argument reached what the fuck level of fuckery. So Laundrie's motion granted. We're going to code red in 3, 2, 1. All right, let's resume this hearing. DEFCON code red.
Statements were atrocious and utterly intolerable in a civilized
Your
community.
statements are atrocious
And
at the
I
moment,
would argue, Your Honor, that a
sir.
statement by an attorney that's expressing sympathy, hope, condolence, trying to explain the difficult situation of his clients is utterly intolerable in a civilized community, then I believe we've lost our way as a society. Now, I know that the plaintiffs allege another statement by Mr. Bertolino, Your Honor, in which he says the news about Gabby is heartbreaking.
They are trying to not laugh at him in court, and I appreciate the emotional roller coaster that Gabby Petito's parents are on right now. We're on this roller coaster with them.
The Laundrie family prays for Gabby and her family. Your Honor, I don't think there's any context in which that statement could ever be outrageous. And regardless of whether the statement was outrageous, the complaint does not allege that Mr. Bertolino
I'm
made
outraged.
that statement on behalf of the Laundries.
Do I
That's the
count?
September 14th statement, so it shouldn't be.
You've
considered
outraged
against
me.
them.
I was less outraged when you started. You've outraged me now.
Mr. Meltz touched on two cases that
You don't have
were
to be
probably
gross.
the foundation of Judge Carroll's order.
I don't have enough
The
coffee
first,
for
Williams
this.
versus City of Mineola, and the site is that is 575 Southern 2nd, 683, and that's a 5th DCA case from 1991. Again, it's 575 Southern 2nd, 683. Your Honor, in that case, a 14-year-old died of an apparent drug overdose, but
should have
there was
landed
also
this
an
plane.
investigation as to whether or not foul play may have been involved. And the Orlando Sentinel published an article describing a party at one of the police officers' homes where they viewed the video and pictures of the autopsy of this young boy, where the audience were joking and laughing, mocking the pictures and whatnot.
This is not dissimilar to the civil case in Los Angeles with regard to Kobe Bryant's crime scene photos. This is a very different case.
Now, the plaintiffs cite this case for the proposition that a grieving family is particularly vulnerable. And I would
Correct.
agree with that. That's what the case and the restatement, they do allow for that.
Accurate.
But I believe the holding of Williams is a little more specific than that. Specifically, Williams said that a grieving family is especially sensitized to any disrespect or indignity directed at the decedent's body or representation of it. The potential for severe emotional distress is enormously increased in that situation. Your Honor, in this case, Mr. Bertolino's statement did not direct any insulting or disrespectful comments against Ms. Petito. So it is distinguishable from Mineola, City of Mineola in that regard. Your Honor, I would also comment F of Section 46 of the Restatement of Torts, which is the section
chat has
regarding,
just put an F in the chat for your
vulnerable family
arguments,
members.
though.
It states, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly sorry, hard for me to say, peculiarly susceptible
It's a
to
hard
emotional
word.
distress
I mean,
by
I get
reason
it.
of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge, where it would not be so if
All
he
of
did
this
not
feels
know.
flagrant and outrageous
Now,
at
this
the
is an
moment.
important part, Your Honor. It must be emphasized again, however, that major outrage is essential to the tort. And the mere fact that the actor knows that the other will regard the conduct as insulting or will have his feelings hurt is not enough. Now, the City of Mineola case, while it supports the notion that grieving families are vulnerable, it does not say that any statement by an attorney for a suspect in a criminal case
How hard this
is
would
per
be
se
to sit in
outrageous.
court
Just because
for
the attorney
Gabby's
for the accused
parents
said.
can't be understated.
There must be major outrage. It is also important to note that the behavior in
they
this case,
were
the
majorly
Mineola
outraged.
case, was by the police officers
Bigly
investigating the
outraged.
death. Now, those police officers held a unique position as to the victim's family, as the victim's family would be relying upon them to fulfill their investigative duties in a professional
Their
way.
lawyer's going to be so mad when he
Your
stands
Honor,
up
the
to
other
start
case,
arguing.
the Liberty Mutual Insurance Company versus Stedman case,
So mad.
which was
mad.
cited in Judge Carroll's order. It was the primary case he relied upon for his determination that context was important. In that case, Your Honor, the insurance company delayed paying for a double lung transplant for one of its insureds. A judge of compensation claims ordered the insurance company to pay for it. Despite that order,
This was kind of an outrageous case.
the insurance company ignored it and continued to delay with the intention that the plaintiff would die, and so they wouldn't have to pay for the lung transplant.
Outrageous, right?
Now, again, Judge Carroll cited this case for the proposition that context is important. First of all, Your Honor, one important distinction is
The case that they're citing is an insurance company that said if we delay our decision, then they will pass and we won't need to pay for the double lung transplant. That's the case that they're talking about.
the insurance company had a duty to pay for this surgery. Not only a contractual duty by the terms of their insurance policy,
Yes,
but they were
next.
also ordered by a judge to pay for it.
The Petitos
And
will argue
they ignored
next.
that duty in delaying paying for the surgery.
Hugs.
Now, Your Honor, I do disagree with Judge Carroll in this regard. The basis,
Of course you do.
for
That's
his
why you're
statement-
here.
or, I'm sorry. The basis for his holding was that Mr. Bertolino's statement was, by all accounts, benign and not outrageous. But if the defendants knew something, or there was other context for the statement, then the statement could be outrageous.
He's bringing this case
Your
up
Honor, I
because
would
it's
argue that if that were the case,
persuasive.
that would impose a duty on the defendants to,
And the other
if
court
they
relied-
spoke
the
at
other judge
all,
relied on it.
to disclose something more than what they did. And that's not a duty that they had. For example, if a reporter asked Mr. Riley and I a question, and we withheld some information in response to the question, we're not legally obligated to provide a complete and total answer with all the information that we know about that subject.
To the reporters?
That's certainly not a
Correct.
duty the law would impose on us. And in fact, Your Honor, in that circumstance, we would probably run afoul of the attorney-client privilege if we disclosed everything we knew about it.
Or could Judge Carroll's order rather mean that with the facts ultimately coming to light through
Thank you, Your Honor, for bringing us back to the facts. She's not as persuaded by this attorney's argument at the moment, which is why she keeps asking questions. Here's why. This attorney for the Laundrie family is now making arguments to dismiss a third time. They made a motion to dismiss the complaint. The complaint was modified to a First Amendment complaint. They argued a motion to dismiss the First Amendment complaint. They lost. There was a Second Amendment complaint, and now they are arguing to dismiss again. So they are actually on the back foot here, arguing, saying that they keep losing these motions. Different than Bertolino's attorney, and that's why the judge keeps asking, because there is a previous ruling from the last judge, and that's what is that the last judge found persuasive for denying the last motion to dismiss. So this is like the third time they're arguing this, which is why the court has a lot more questions for him, because the court's basically like, why should I do anything different than the last judge did? Like, why?
discovery and otherwise, that this issue may be one that is better suited, this question
Summary
may be one that's
judgment.
better suited for summary judgment. or
Agreed.
trial.
I think you're right, Your Honor. I mean, I do think that that's what he was.
Well, if you think she's right, why are you making another motion to dismiss? Just make your motion for summary judgment, sir.
that he was getting at was, I'm going to give the plaintiffs an opportunity to see if they can develop some additional facts, and then I'll reconsider this issue at summary judgment.
I mean, but we're still at motion to dismiss, so we're still kind of at the same spot that he was at.
Yes, Your Honor, we are still very much at that same spot.
Okay.
Although, again, as I said, Your Honor, my
You're done.
feeling is
Where's
that
Nicole Byer? Where's Nicole Byer?
even
You're
if
done.
the plaintiffs had some other information that they
Sir?
didn't disclose in that statement, and that's uncovered in discovery,
Can we be done?
that doesn't mean that they had a duty to disclose it.
Sorry if that was loud.
They aren't required to disclose everything they know every time they speak. That even in this context, Your Honor, Mr. Bertolino's statement was very clear that they were not going to say more based upon the advice of counsel. That's important context for it. That conveys that
Okay.
you may not like what we said here. It may not be enough. It may not be exactly what you would want us to say, but we
Who's
have
you?
a right to rely on the advice of our
internet?
attorney and not say
The internet definitely wanted them to say more.
That I think is an important distinction, Your Honor. Your Honor, another issue related with the Stedman case, I know the plaintiff cited on the issue of unequal positions, which again is another subparagraph of Section 46 of the restatement.
Sir, I think maybe
But Your
you land
Honor,
the
my
plane
position is that
now.
that's really a red herring. So what the unequal position section of the restatement said, it's subsection E of 46. The extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with the other, which gives him actual or apparent authority over the other or power to affect his interests. Thus, an attempt to extort money by a threat of arrest may make the actor liable, even where the arrest or the threat alone would not do so. In particular, police officers, school authorities, landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous. The extreme and outrageous nature of the conduct may arise not so much from what is done as from
don't wanna
abuse
have
by
to
the
argue
defendant of
this.
some relation or position which gives the defendant actual or apparent power to damage the plaintiff's interests. The result is something very like extortion. Successful actions have been prosecuted in this context based on outrageously high pressure tactics of collection agencies, other creditors, and insurance adjusters seeking to force an unfair settlement. And Your Honor, that's cited from Dependable Life Insurance
I think
Company
that's
versus Harris.
distinguishable.
That's 510 Southern 2nd, 985, specifically page 988.
Okay.
And that's the 5th DCA case from 1987. So, Your Honor, somebody involved in a criminal investigation making a public comment is not really what's intended by this subsection. The conduct must be something like extortion, where the person abuses their authority to extract something from the other person, and that's really not what we have here.
I mean,
Your Honor,
I
I
agree.
mentioned
What we don't
intent
have
earlier.
is extortion. I
Intent
agree
earlier.
with
And the
that.
plaintiffs have alleged that the Laundries maliciously and willfully inflicted emotional distress. Now, in both of these cases that I just discussed, the intent is fairly clear. In Williams, police
You're just
officers who were supposed
restating
to
your
be
written
investigating the victim's
filings,
case openly
though.
mocked and joked about his death during a party. By all objective measures, very unprofessional, and done with the intent to mock the deceased, to make fun of him. And, Your Honor, just like Judge Carroll mentioned, duty is important in this context. And you could say that police officers have a duty, or at least an expectation, to be professional with victims and their families. Now, in the Stedman case, the insurance company clearly acted with the intent to disregard the judicial order, and with the hope that the plaintiff would die.
That's
The
very
insurance
different.
company,
I agree. I
the insurance
understand
company
why you're distinguishing
clearly
it.
acted with ill intent.
But the-
Now, nothing about Mr. Bertolino's state comes close
Oh,
to
that's
that
why you're
level of
arguing it.
callousness.
Okay.
Nor did he have a duty to say more than he did. And other than general recitations of intent,
But he
the complaint has
chose
no
to.
specific factual allegation demonstrating that the Laundries or Mr. Bertolino harbored an intent to act outrageously or to do harm, which they're required to have. Rather, Your Honor, again, if you look at that first paragraph of his statement and the last paragraph of his statement, the first paragraph being that we're really sorry about this, but it's difficult for both families. We know you're going through something difficult, but we are too. And then the last paragraph where he says, I'm sorry, we can't say more based on my advice as an attorney. Now, the plaintiffs acknowledge that their cause of action on these facts is novel. And it is novel because Mr. Bertolino's statement is not outrageous. Everyone involved in this tragic saga had rights that protected them. And those rights may have worked to the detriment of others. But the exercise of those rights is not objectively outrageous. We can all imagine where the exercise of rights may be subjectively outrageous to the person who is disadvantaged by the exercise. But objectively, the law must protect the exercise of rights.
They
Now, this
didn't
leads me to my
exercise
next
their
argument,
rights.
Your Honor, which is that Mr. Bertolino's statement was legally protected. There's
That's
two ways in which it
true.
was protected. The
Well,
first, the privilege to do what is legally permissible, and
That's
second, the litigation
interesting.
privilege.
I should
So
say.
from the first recognition of the tort of intentional infliction of emotional distress, the Florida Supreme Court has emphasized that the conduct, although it would be otherwise be extreme and outrageous, may be privileged under the circumstances. The actor is never liable, for example, where he has done no more than insist upon his legal rights in a permissible way, even though he is well aware that such insistence is certain to cause emotional distress. And Your Honor, that's the Metropolitan Life Insurance Company case, which I cited earlier. It's 467 Southern 2nd, 277. Florida Supreme Court, 1985.
I don't
And this,
know if
this
I need the
principle has been
extreme
upheld many
close-up on
times since,
Stephen
and we cite some of
Bertolino.
those cases in our brief.
Thank you.
Now, as an initial matter, our first motion to
Could we just
dismiss
see the whole
discussed the
courtroom?
number of rights that protected the Laundries from having to say
That'd be
it.
great.
And as Mr. Bertolino put
The
it in
court
his
does
statement,
not seem to have
they
put a
could
time
remain in the
limit on them.
background. That was their legal right.
The court can always
And
say,
Judge
thank you,
Carroll
counsel.
summed up that finding that the Laundries had no duty to do anything, even if the plaintiffs wanted them to do more.
And that's
As I discussed,
a
I
key
disagree
point
with
here.
Judge Carroll with the regard as to whether or not that duty should be extended to whether they needed to say more in
Yes,
the
yes,
statement, in Mr. Bertolino's statement.
They could have said nothing. We know.
I would argue that the law doesn't impose a duty on them to say more than what they did. Now, as it relates to Mr. Bertolino's statement more specifically, there is an additional way in which he was exercising his professional obligation in a permissible way. ABA Model Rule of Professional Conduct 3.6 permits an attorney
Hi,
to make
buddy.
a statement to protect his client from adverse publicity. Specifically, that rule says,
George went the
notwithstanding
long way
paragraph
around,
A,
does not say
a
hi.
lawyer may make a statement that a reasonable lawyer would believe is required to protect the client from the substantial, undue, prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. And again, that's ABA Model Rule of Professional Conduct 3.6, subsection C. Now, plaintiffs argue in their response that there are not enough facts within the second amended complaint to infer that Mr. Bertolino's statement was made under these circumstances covered by the rule. Your Honor, I would disagree. So, first of all, the plaintiffs allege that Brian Laundrie murdered Gabby Petito. That's at paragraph 16. They reference the search.
Sir? Yes. The Petitos allege that Brian Laundrie murdered Gabby Petito, but Roberta Laundrie also acknowledges that, your client acknowledges that in her affidavit, and he admitted it in writing. So I think we know that that's what happened, hence the confused look on the faces of Gabby Petito's parents.
In Wyoming, paragraph 28. They allege that the Laundries and Mr. Bertolino were assisting Brian to flee the country. Again,
That
they vehemently oppose that, but
is-
they allege it.
Is
They specifically
different.
set forth at least 3 public statements by attorneys that were published to the media
Sir?
for both.
The court has to take all of this as true, so why tread this ground? Oh, now we have all the cats on the desk. Okay.
Families. It's paragraph 31, 35, and 38. They allege Mr. Bertolino's September 14th statement was intended to be disseminated nationwide and was broadcast in news reports in Florida
And it
nationwide.
was.
Again, paragraph 31. They also allege that Mr. Bertolino released, I'm quoting, numerous other statements regarding Christopher Laundrie, Roberta Laundrie, and Brian Laundrie to the national press. Paragraph 33. And they allege that Mr. Bertolino gave a televised interview in October of that year, paragraph 27.
He did.
There are enough allegations to support that there was media attention on the case.
I understand where Gabby Petito's parents are coming from saying, but he did. The reason he keeps saying it's alleged, even though I also have taken picky issue with it, is because he's not referencing that it's not true, like it's alleged. He's using it in context of this is what's in their complaint. So he's using alleged as they're saying in the complaint, not alleged as in it might not have happened, if that helps give context to it. It sounds odd when it's like they've alleged this and you're like, but that's an actual fact. He's using alleged to mean in the 4 corners of the complaint. Hopefully that helps clarify the way he's saying it.
Now, the rule itself does not require a certain level of publicity that the attorney is responding to. It just says recent publicity. It could be a response to one article about the case, but certainly the plaintiffs have alleged enough in here, and enough in their second amended complaint to support that there was publicity on the case that Mr. Bertolino could be responding to. Regardless of whether the facts of the second amended complaint fit neatly into the model rule, the standard is whether Mr. Bertolino and the Laundries were insisting on their legal rights in a permissible way. Even if every element of model rule 3.6c is not satisfied by the allegations of the complaint, the mere existence of the rule demonstrates that Mr. Bertolino had a good faith basis and legal right to make the statement.
You should have led with this and left all the rest of it
Now,
to the side.
plaintiffs argue in their response that if Mr.
you've already
Bertolino was
lost
issuing
me
a
when you got
statement to
to the
protect his
better
clients,
arguments.
he would have given what the plaintiffs wanted, which was Gabby's location. First, the rule does not specify what kind of statement an attorney must make. Second, such an argument would impose a duty on the defendants to, if they spoke at all, to disclose everything, which again, we don't believe the law imposes that duty. And then third, Your Honor, the statement Mr. Bertolino
That's the
gave,
most
while not
interesting
satisfying to
question
everyone,
here.
was the best he could do under the
I don't know if
circumstances.
it was satisfying to anyone.
It acknowledged the plaintiff's grief, while also informing them that the Laundries could not say more
The chat's
based
now
upon
singing
the
show
advice of
tunes
counsel.
about being satisfied.
Now, Your Honor, I'll turn to the litigation privilege.
Gosh.
Before you do that, with the
Thank you, Your
ABA
Honor.
model rule, what would provide that as being legally permissible?
Well, Your Honor,
He's not a member of the. I mean, he's a member of the New York bar.
exactly. Your Honor,
Yes.
So, and he was making allegedly those statements in Florida.
Yes.
So, are those model rules are intended to be adopted by bar associations? So I mean,
The chat's
I
asking.
don't know that we have one in Florida bar that.
Your Honor, you're right. I don't know that we do. Although I would say I don't believe Mr. Bertolino made the statement in Florida. I believe he
Okay.
may have made it in Someplace or someplace else.
Obviously, he's
Obviously,
not governed by the Florida bar.
exactly, Your Honor. He is not.
So, I mean, I guess that's the ABA model rule. Those are just what they say. Model rules. We have model rules.
The judge, sir, why are you arguing shit that doesn't matter?
And laws nationwide. That doesn't mean that they're actually laws we have to follow.
No, you're right, Your Honor. And it's not so much that it's a law that he would be required to follow, but what it is a recognition.
No, you're
that
trying to say no.
an
You're
attorney
trying to say
can
it's a
make
lawful
like
statement.
this, a public statement like this, and not run afoul of rules of professional conduct. It is a
That's not
permissible
the
rule,
argument you're
not so
trying
much
to
a
make.
rule that seeks
But
to.
it's not a permissible rule in the state of Florida.
I agree
Okay,
with you.
all right.
Yes, it's not a permissible rule in the state of Florida. Yes.
This judge needs a better
I would agree with
chair.
that point.
I just wanted to make sure that there wasn't something similar in New York or that you were going off.
I don't know about New York, Your Honor. I do know that in Florida, I don't believe that rule is part of our.
Get her a bigger chair. Yo, she needs a Judge
I'll bring it up.
Newman-esque chair.
While we're taking this
I
short
want
break.
all of the judges to have large Judge Newman-like chairs. It is what I demand when I am watching court on TV. Large chairs.
So, Your Honor, turning to the litigation
Newman
privilege.
chairs. Throne.
Now, the litigation
Judge-
privilege is based on a recognition
Judge
of the
Thrones.
necessity that certain persons,
Get
namely
her a
attorneys in this
throne.
context, because of their special position or status, should be as free as possible from fear that
She is
actions
trying
in that
so
position
hard
might have an adverse effect
to
upon
move
their
this
own
along.
personal interests, which is really what we have here. To accomplish this, it is necessary for them to be protected, not only from civil liability, but also from danger of even an unsuccessful action. Now, Your Honor, while that's important to my clients, is that if a principal's liability rests solely on the doctrine of respondeat superior, a principal cannot be held liable if the agent is exonerated. So if Mr. Bertolino can invoke the litigation privilege, then my clients cannot be legally responsible for whatever conduct he did that caused the invocation of that privilege. Now, Florida has recognized both absolute immunity and qualified immunity in the litigation privilege context. Now, typically, the absolute immunity is afforded to statements made in the course of judicial proceedings or trials. But it also includes proceedings before a competent court or magistrate in the due course of law or the administration of justice, which is to result in any determination or action by such court or officer. This privilege extends to the protection of the judge, parties, counsel, and witnesses, and arises immediately upon the doing of any act required or permitted by law in the due course of the judicial proceedings. And then here's the important part, or as necessarily preliminary thereto.
Okay.
And that, Your Honor, that's Fridovich versus Fridovich. That's 598 Southern
Sir?
2nd, 65,
You,
Florida
you
Supreme
are
Court.
now like jumping
1992.
laser sharks.
And that's
The
citing
judge
another
is
Supreme
done.
Court Ainge
We-
for that same proposition.
I am also done.
Now, Your Honor, as we pointed out in our brief, the Florida Supreme Court has not addressed whether absolute or qualified immunity would extend to a lawyer's comments in a situation like this. As the plaintiff's cause of action is novel, so is our request to extend the litigation privilege in response to it.
Yeah, I've never seen
Now,
the
the Florida
litigation
Supreme Court has
privilege
extended the
extended
absolute
in
privilege in
this
certain
context.
pre-litigation contexts, specifically the Ainge case
I think you would have to argue that at summary judgment. I don't know if you're getting to that today.
that I reference. It's Ainge versus State, 123 Southern.
And I think the other
Southern,
judge already
It's an
denied
old case,
this.
Southern, 916,
Oh, covered in
and that's from Florida, 1929.
Fred!
And in that case, Your Honor, the court found that the absolute privilege barred an action for defamation based on statements made in the office of a county judge
It's
to
so
whom the defendant had
different,
gone to obtain a warrant.
sir.
Your Honor, also Robertson versus Industrial Insurance.
Sir, there was no litigation pending. The statements in the course of a search warrant is closer to litigation pending. It is a function of law, getting a search warrant. Making statements to the press when there is no legal case pending is not going to be covered by litigation privilege. You can't just enlarge it to cover this circumstance.
Company, that's 75 Southern 2nd, 198, that's Florida.
You're getting
Florida Supreme
two
Court,
Vincent Van Goghs.
1954. Absolute privilege applied to defamatory
not a
statements made in
defamation
letter
case.
to the insurance commissioner.
It's not
used
a
to initiate
Wendy's.
license revocation proceedings.
It's not a Burger King. You can't have it your way.
The page number for the Ainge.
Sure. So
Southern.
yeah,
The judge
123
is like,
Southern
"Ser-
916.
Seriously.
Now, the Florida Supreme Court has also recognized a qualified privilege rather than an absolute privilege in the context of statements made to police in a criminal investigation prior to the initial
Not
to the
applicable
initiation
here.
of criminal proceedings, and that was the Frutovich case that I cited to you earlier.
You cannot
Also,
extend the litigation privilege from statements made to law enforcement to statements made to the media when there is no case pending. Lawyers have a First Amendment right, but the rules that govern what a lawyer says to the media when there is no litigation pending is very different than what governs when litigation is in fact pending. And this is not a defamation. Okay. Emily, stop. Just keep reading.
Delmonico versus Trainer. That's the site for that is 116 Southern 3rd, 1205, Florida Supreme Court, 2013.
Going to wear my goat like a ring
And in that case, Your Honor, the Supreme Court extended
so we can.
the qualified privilege to statements made by an attorney as they undertook an informal investigation and interviewing witnesses.
Here we are.
So now, Your Honor, we acknowledge that this
Left-hand
case does not
side.
fit neatly into any of these examples. And we would be asking the court
That's
to
an
extend the privilege
understatement. No.
to the context where an attorney makes a public statement in the face of a criminal
Please enlarge
investigation
it, Your
while
Honor.
it's findings.
No.
But again, Your Honor,
Sir,
relying on
no.
Model Rule 3.6, there is a basis for doing so. If rules of professional conduct contemplate an attorney making a statement or even compelling such a statement to fulfill a duty to defend his client, then there is no reason that such a statement should not at least be protected by a qualified privilege. We can all think of countless examples where an
broke my
attorney for a
gavel.
defendant
Damn it.
or makes a public declaration of innocence, or a prosecutor makes a public declaration of guilt before the case is decided. And now every one of those cases should not trigger a civil action for intentional infliction of emotional distress if the case turns out differently than those proclamations. Your Honor, the basis for whether an absolute or qualified privilege, the basis of such a privilege is for lawyers is to permit a free
broken our
adversarial
gavel.
atmosphere to flourish, which
Damn it.
atmosphere is so essential to our system of justice. That's Sussman versus Damien, 355
The
Southern
gavel
2nd,
was so
809,
annoyed it yeeted itself.
Florida, 3rd DCA, 1977. In fulfilling their obligations to their clients and to the court, it is essential that lawyers, subject only to control by the trial court and the bar, should be free to act on their own best judgment in prosecuting or
have
defending a
another one
lawsuit without
somewhere.
fear of later having to defend a civil action for something said or written during the litigation. A contrary rule might very well deter counsel from saying or writing anything controversial for fear of antagonizing someone involved in the case and thus courting a lawsuit, as a result which would seriously hamper the cause of justice. And again, Your Honor, that's a quote from the Sussman case. Your Honor, it is an important point that Mr. Bertolino is an officer of the court, and subject to the court's jurisdiction and also regulation by his bar association.
Is he subject to the court's jurisdiction as a lawyer in New York? Is he though? I can't believe I broke my gavel. For those of you that have been around since the early days of my YouTube channel when I used to do tech, I think the reason that I was terrible at it, one, is I dropped everything I talked about. Everything I unboxed, I dropped. So I'm not surprised this broke. But I don't know if Bertolino is subject to the rules of Florida. He's an attorney in New York. So I don't agree.
And if he truly did step out of line, he is subject to control by those entities. His
By New
clients,
York!
again,
Oh, I've got
also
another
should not
gavel in
face
the other
civil
room. I'll
action,
find it.
Merely because of his comments about an ongoing public investigation. Now, plaintiff's response discusses the case of Ball versus D-Lights Enterprises, Inc. The site for that case is 65 Southern 3rd, 637. It's a 4th DCA case from 2011. And Your Honor, all these cases I'm citing should be in the binders, cited and everything.
Binders of
if-
cases.
Yeah.
Stacks of cases.
And I don't want to cut you off, but
Please do.
I've given both of you, like, at this point, 45 minutes for Mr. Metz and 45 minutes for, close to 45 minutes for you, and I just want to make sure that.
Understood, Your Honor. I will move more quickly. I will move more quickly.
No,
So,
say
Your Honor, in
less.
the Ball case.
Say less. Don't
in
move
that
more
case,
quickly.
A party to
Don't
a
do it
lawsuit published
faster.
some disparaging remarks
Say
on their own
less.
commercial website about their opponent's business practices.
You don't need to
Now,
rewrite
I can
your-
understand in that context why the litigation privilege would not cover it, because it was essentially a party to litigation disparaging a business competitor in a commercial context, entirely
love this,
commercial
Judge.
context, and it just
So
happened that the
far,
two
I'm very
entities
happy.
were also engaged in litigation. This context is different, Your Honor. The statement is made by an attorney. And there is a rule of professional conduct that permits that statement.
Sir.
That type of statement is much more closely aligned with the,
The
litigation
court
privilege
has
than is
already
the statement by a
asked.
private entity on their website in a commercial business context.
How this is
Now,
relevant and it's not. The court's already questioned you about this.
At
Just
what stage are these cases that you're citing getting resolved?
Yep.
Are they getting resolved in a motion to dismiss?
nope. These are summary. These
Some
sound
of
summary
them,
judgment.
yes, Your Honor. Although, I mean, I
Which
would
one?
submit, Your
And
Honor.
I will look through them.
Yes,
but
the litigation privilege probably is something that requires more factual development
Litigation?
in certain contexts. I mean, now there may be cases where it's very obvious from the four corners of the complaint that there was a case that was initiated. I'm sure, the court could take judicial notice of certain things, if a case had been filed, if the case related, and things like that. So that's obviously not the context we have here.
Right.
I do agree with you on that.
all right.
I do agree with you on that. Your Honor, Mr. Meltz covered causation. I'll just touch on it briefly here. So the Florida Standard Jury Instruction 410.6, which is the intentional infliction of emotional distress jury instruction, says that extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress.
look, we got back to the
so that
point
it can
of these
reasonably be said that,
arguments.
but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. Now, the jury instruction does allow for concurring causes, but again, even a concurring cause must contribute substantially to producing the distress.
Okay.
I don't think the plaintiffs dispute that there were concurrent causes, that they were already suffering distress.
boy. I hate this
prior to
argument,
Mr. Bertolino's
but I get
statement,
it.
even after Mr. Bertolino's statement, that there was.
This is a legally proper argument. He needs to make it delicately, I think. But he's arguing that the distress felt by Gabby Petito's parents is not because of anything the Laundries did. It's because of the overall circumstance of that she was missing and they were afraid that she was dead and all the rest of it. So that's what he's trying to argue. This is a legally proper argument. He should have leveraged this at the beginning of his argument because now he's already kind of lost the court. We've heard the court ask a lot of questions about it. This has been denied multiple times. As to the Laundries by the court the last two times he did this. So it's not gonna change anything.
It's not necessarily due to anything that Mr. Bertolino said. But Your Honor, really what is critical here is the word producing or substantially producing. Because as Mr. Metz pointed out, paragraph 35 of the complaint, within the statement by the plaintiff's attorney, Richard Saffold, he said, we haven't been able to sleep or eat and our lives are falling apart. Again, not caused by Mr. Bertolino's statement, just caused by the circumstances of the disappearance of their daughter. And also the way that the plaintiffs have alleged causation in this case is interesting. They say that the defendants could prevent such additional mental suffering and anguish of Joseph Petito and Nicole Schmidt by disclosing what they knew about the well-being and the location of the remains of Gabrielle Petito. It's paragraph 39. Failing to prevent mental suffering that is already occurring is not the same as producing it. The distress has already been produced. It's ongoing. And really what the plaintiffs are arguing is that the Laundries failed to stop it. Again, I think it's also important to point out that they allege the Laundries caused their emotional distress by not disclosing what they knew about the well-being and location of the remains of Gabby. And as Judge Carroll found, disclosure is not a duty they had. And it was also, Gabby's location is not a fact that the Second Amendment complaint alleges the Laundries knew specifically. But what we are dealing with specifically here, Your Honor, is whether Mr. Bertolino's statement produced their distress. But they don't allege that the statement produced distress. They allege that what was not in the statement caused them to suffer continued distress, which again is not the same as
This
producing.
argument should have gone at the beginning.
Your Honor, Mr.
He's
Meltz also
just
touched on this, so I won't
basically
spend too much time on
reading
it, but
out his
for
written
conduct to
motion
be
again.
actionable as an intentional infliction of emotional distress, the conduct must be
For
directed
almost an
at the
hour
plaintiff
now.
and in his or her presence.
The
And that's
court
Dunkel
set
versus
aside
Hedman,
less than 60 minutes for these arguments.
Cases 2016,
Total.
Westlaw 487-0502. And it's a Middle District of Florida federal case from 2016. We cite a number of other cases, Your Honor. I'm not going to do that now. They're in the brief for that same proposition.
Great.
Now, in their response, Your Honor, the plaintiffs, in arguing against the application of the litigation privilege, which is at page 24, paragraph 55 of their response, they acknowledge this fact. They say, furthermore, the statements made by Mr. Bertolino were not made to anyone involved in any potential court proceeding. So the plaintiffs are correct. Mr. Bertolino's statements were not directed at the
I
plaintiffs or
have him
anybody
on 1.2.
in any potential court proceeding.
I've got him sped
And as a
up.
result, they don't have a cause of action. for
And he's
intentional
still talking
infliction of
forever.
emotional distress. Now, Your Honor, my final argument, my plausibility argument, as I mentioned earlier, it's not sufficient for the plaintiffs to plead opinions, theories, legal conclusions, or argument, and the court does not have to accept those as true. Now, the two cases that set the minimum standards for federal pleading, which Florida courts have expressed acceptance for, are Bell Atlantic versus Twombly and Ashcroft versus Iqbal. Now, Your Honor, I would submit that this complaint is full of opinions, theories, legal conclusions, and argument. As mentioned earlier, there was only one allegation of a conversation between Brian and his parents in the whole entire complaint. And even that allegation begins with the phrase, "it is believed." There are no allegations that the Laundries learned any other information than that one allegation. Now, I want to focus on the allegations regarding the state of mind. Now, specifically, they allege that Mr. Bertolino's
we need
statement was
to?
outrageous, and that all of the defendants, all three of the defendants, acted willfully and with malice in issuing it. Now, plausibility means that once the complaint has been whittled down to its non-conclusory allegations, the court undertakes the second step of determining whether the complaint states a plausible claim for relief. The plausibility standard asks for more than a sheer possibility the defendant has acted unlawfully. Where a complaint pleads facts that are merely consistent with the defendant's
my
liability,
computer is
it
getting a
stops
little
short of the
taxed
line
on
between
this.
possibility and plausibility of entitlement to relief. Now, again, the plaintiffs have alleged that each defendant individually acted willfully and maliciously toward the plaintiffs. Now, it doesn't allege a conspiracy or some other agreement amongst the defendants. It doesn't allege that any of the defendants forced another one of them
The
to do something.
Laundries have argued this.
The complaint doesn't
3
even
times
allege
now.
that Mr. Bertolino and the Laundries ever spoke about the statement before it was issued. It alleges all three independently had that heightened mental state to inflict
No,
severe
the
emotional
Laundries
distress.
are not there.
Now, the plaintiffs have to advance
They
that
have
theory
not been
because
in
this
court
is an
ever for
intentional
this.
tort. This isn't a negligence action where the Laundries are liable for Mr. Bertolino's negligence simply by employing him. Likewise, Mr. Bertolino is the one who made the statement. So he can't be liable if he didn't have the intent to harm. But that dictomy creates an implausible scenario. If Mr. Bertolino, as plaintiffs alleged, harbored such malice toward the plaintiffs to intentionally inflict emotional distress, to deliberately commit an act that goes beyond all bounds of decency, he would have been acting for himself, not as an agent, as an attorney for the Laundries. If Mr. Bertolino allegedly committed an intentional tort for his own purposes and not on behalf of his clients, then his clients cannot be liable for the acts of their agent, and the Laundries should be dismissed. And we cite the Diaz versus Associated Loan Company. It's 99 Southern 2nd, 279, Florida, 1957, which just says the
Which you don't
liability
need
of the
to
master for
restate.
intentional
You
tort
said you
acts
weren't gonna
which
restate
constitute
it.
legal wrongs can only arise when that
And
which
now
is
we're
done is
restating.
within the real or apparent scope of the master's business. It does not arise where the servant has stepped aside from his employment to commit a tort which the master neither directed in fact nor could have supposed from the nature of his employment to have authorized or expected the servant to do. If Mr. Bertolino harbored the mental state necessary to commit something so egregious, he could not at the same time fulfill his role as an attorney to the Laundries. It's hard to imagine a scenario where an attorney could commit an intentional tort and still be acting in his professional duty to his client. Making a statement that is utterly intolerable in a civilized society
Chat, I will be
wouldn't
right
be
back.
serving any client's interest. And if Mr. Bertolino, as the Laundries attorney, advised or even permitted his client necessary to commit the tort,
I changed my mind.
they would have simply been allowing their attorney to act as their advocate.
I feel like
something
he's
that is
almost
not
done.
outrageous or to be regarded as atrocious and utterly intolerable. Now, if there is an obvious alternative explanation for the Laundries' activities, the court can choose the more plausible conclusion, where the conduct is more likely explained by lawful behavior the complaint does not plausibly allege a claim for relief. The most obvious alternative explanation is that this was a very upsetting time for everyone, and Mr. Bertolino was simply trying to express that without doing any harm to his clients. As his statement said, on the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. Now, Your Honor, in conclusion, the plaintiff's pain and frustration with how the investigation into Gabby's disappearance occurred is understandable. Absolutely. We all have sympathy for them.
Really?
But as judges
Do
and
you?
lawyers,
I have
we know
questions.
that almost every case, criminal or civil, involves some pain and frustration for the parties involved. Now, most of the
Fair
time,
point.
not to the level of losing a child, but there is some discomfort. As humans, we have yet to craft a perfect system where everyone is protected, the victim, the accused, their families, but that would be impossible because everyone has rights. And often those rights butt up against each other. For that reason, we have legal guardrails to keep everyone involved in an
He
investigation.
should have
from
led
being
with this
sued
because
every
it's
time.
too far afield
While the
now.
plaintiffs deserve our sympathy, they just don't have a case against the Laundries. Thank you, Your Honor.
That's why you wanted to close with it.
We've been going for about 2 hours. Would anybody be objectionable to like a 5-minute break?
No,
Okay, let's do that. Mr. Riley,
the
you don't
court
mind
needs to
since it's your
pee,
time
so
to
do
go
I.
next?
I was going to ask anyway.
Excellent.
All right. The court is taking a potty break. I am going to zoom because we're on a slight delay. So we have the ability to catch back up to this hearing. And when we resume this hearing, we're going to be resuming with the Petito's attorney. So let me just take this down and make sure we get to where we need to be time-wise in court. So we are going to resume with the Petito's attorney arguing. We have now heard the argument for both defense attorneys on their motions to dismiss the second amended complaint. I should have swooped. I didn't. I'm going to make sure that we resume as court resumes. Then I might step out for just a quick second while we start to hear the Petito's attorney's argument. There was a lot in the argument from the Laundrie's attorney, but it's truly mostly the same that they've argued twice before. It wasn't always this attorney arguing, but it's the same arguments, the same substance, and it has failed, well, twice. As to Bertolino, that's a bigger question. Will the court dismiss the complaint as to Bertolino with or without prejudice? We will see. We've gotten to the point where the attorneys are coming back into the courtroom now, so I'm going to continue to fast forward this as we catch up in real time. This court hearing is going much longer than anticipated because the court had set aside about 60 minutes for the entire thing, and we're well beyond that at the moment. So we're going to keep zooming. To everyone who's new here, thank you for joining this incredible community of law nerds and coming in and having a conversation with us. It's fantastic. I can't just leave an avatar up. When I turn off my camera, it's not allowing me to do that. So I don't think I can. But we'll see here. Let's continue to zoom to get us into real time. This is, my computer is giving me like all of the business at the moment. So let's continue on. Let's see. All the attorneys are back, but they're very casual, so that indicates to me the court's not back yet. All right. When everybody kind of straightens up, we'll hear if the court is back. All right, still no audio. So we are going through the zoom. There's the court. All right, we will be back on the record. The Petito's attorney will be arguing against the two motions to dismiss as court resumes.
I would, Your Honor. I promise I won't take 2 hours.
Oh, thank God.
May it please. I would, Your Honor. I promise I won't take 2 hours. May it please the court. I think if Judge Carroll were here today, the first words out of his mouth would be, didn't I already decide these issues?
Yes.
Most all of the issues that have been raised here today have already been decided by Judge Carroll in a very well-reasoned decision. The plaintiffs, or the defendants in this case, are simply looking at another bite at the apple to try to argue the same issues and hoping that you, as being relatively new to the case, will overrule what Judge Carroll previously ruled. There's been no new evidence that they've submitted, no new arguments that they've made that would make any difference. And for them to suggest that Judge Carroll didn't consider some of the elements of a cause of action of intentional infliction of emotional distress when he rendered his opinion is frankly insulting to Judge Carroll. The only change that occurred in this case between the first amended complaint and the second amended complaint is that Attorney Bertolino was named as a defendant. There were some jurisdictional allegations that were included, and there was a second article that was included. But beyond that, the bulk of the complaint, the majority of the complaint, the structure of the complaint has been ruled on in a motion to dismiss before Judge Carroll, and he found that it was sufficient to move forward. This case is not based upon silence. We're not arguing that the Laundrie's refusal to provide information regarding Gabby.
I had to let my new clerk in.
Okay.
So we should be okay. She's listening in the class. Okay,
All right.
the circuit and then also this.
We're not arguing that the fact that they kept quiet about whether Gabby was living or wasn't and where her body was located is the subject of this cause of action. It's not. This is about the statement that was issued by Mr. Bertolino on September 14 of 2021, issued with the knowledge that Gabby Petito was deceased, issued with the knowledge, and we did suggest in the complaint at paragraph 28, that they knew where Gabby Petito's body was located. With that knowledge, and knowing that Joe Petito and Nicole Schmidt were desperately searching for any information about their daughter, they issued a statement. And by the way, when that statement was issued, counsel, Mr. Meltzer, suggested that Mr. Bertolino was simply the attorney for the Laundries. He was more than that. He was also their spokesperson. He did all their speaking for them, whether it was related to a legal representation or not. He did all of the speaking for them. The statement that was issued on September 14, there's 3 paragraphs. The first paragraph says it's a difficult time for the families. It's a meaningless paragraph in terms of this litigation. The third paragraph says there will be no more statements issued, or that Laundries won't speak. Nothing to do with the crux of that statement, which is the subject of this cause of action. And that statement is, it is our, and I highlight our, understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our, and again, I emphasize our, hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. Counsel has suggested that this statement wasn't directed towards the Petito family specifically. But who else, if it wasn't directed to them, was it directed to? What was the purpose of this statement? What reason would there be to make that statement other than to express the hope to the Petito family that she would be located? Who else would they be expressing the hope to? Mr. Bertolino's suggestion that the statement was issued only on behalf of the Laundries is belied by his own language in that statement where he says our on multiple occasions. The defendants want you to take that statement and read it entirely out of context. They want you to believe that it was the sincere expression on the part of the Laundrie family and Mr. Bertolino that they hoped that she would be found. And if you looked at it in that context alone, arguably I would agree, it is harmless. It could sound like a heartfelt expression of a true desire that they hope that Gabby Petito was located. But when taken in context and looking at all of the allegations in the complaint, it suggests that they knew when that statement was made that Gabby was deceased, that they knew where her body was located, and they knew the family was grieving. Mr. Meltz did a good job of cherry-picking portions of the complaint and taking them out of context, but let's put it in context. On July, and these are all allegations that are in the complaint,
Because under
July
the case
2nd of
law,
2021,
the
Gabby and
context
Brian embark
matters
on a
to the
Western U.S. journey
objective
in Gabby's van,
interpretation.
paragraph 10 of the complaint. Gabby called her family almost daily, paragraph 13. There was no contact with Nicole Schmidt after August 27, 2021, no contact with Joseph Petito after August 21 of 2021. That's paragraphs 14 and 15 of the complaint. The paragraph 16 says, there's a belief that Brian murdered Gabby on August 27 of 2021, and the cause of death was blunt force injuries to the head and neck with manual strangulation. Paragraph 16.
That's been proven.
On August 28, Brian Laundrie contacted his parents.
Sorry,
On
I had to
August
grab a
29,
snack.
his parents contacted Attorney Bertolino, and a
I thought I
retainer
would
was sent
have
to
time
Attorney
for lunch.
Bertolino on September 2 of
been a very long
2021.
hearing.
That's paragraph 20. September 1, Brian returns home in Gabby's van without Gabby. Paragraph 22. On September 6 of 2021 through September 7, 2021, the Laundries go on vacation with Brian while Gabby is missing. Paragraph 25. September 14, Mr. Bertolino issues a statement that I just read a moment ago. And again, as I said, paragraph 28 does indicate we believed that at the time it was issued that they knew the whereabouts of Gabby Petito's body. He also issued a statement on October 23rd of 2021 in which he said when Brian Laundrie left his home on, I believe it was the 13th of September, he was grieving. Definition of grieving is feeling sad because someone
This
has
is a
died.
good argument. I liked it in
On
their
September
written
19
motions.
of
I still like
2021,
it.
Gabby's remains are located, and Mr. Bertolino issued another
It's a
statement.
good
The
argument.
news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family. Her death wasn't news to the Laundries or Mr. Bertolino. They knew she passed away. The only news to them was that Gabby had finally been found. Putting Mr. Bertolino's statement in context, as Judge Carroll noted in his opinion on the prior motion to dismiss, if the Laundries and Bertolino knew that Gabby was dead, knew the location of her body, and knew her parents were frantically looking for her, the statement was particularly callous and cruel and is sufficiently outrageous to state claims for intentional infliction of emotional distress. That hasn't changed. None of that has changed by the filing of the second amended complaint. As the court knows, the motion to dismiss must be confined to the four corners of the complaint. I have to accept as true the plaintiff's allegations and draw every reasonable inference from those allegations in favor of the plaintiff. Defendants have taken liberty in their motions, as I have indicated in my brief, by bringing facts in that are not a part of the four corners within the four corners of the complaint, and I'll discuss that.
I want to hear that
As was
argument.
noted, intentional infliction of emotional distress became recognized as a cause of action by the Florida Supreme Court in 1985 in the Metropolitan Life Insurance case. And the Supreme Court adopted Restatement of Tort Second, Section 46, which sets forth the requirements necessary to prove a intentional infliction of emotional distress. They are deliberate or reckless, not intentional, deliberate or reckless infliction of mental suffering. Both counsel, I believe, stated that it has to be an intent to commit emotional distress. That's not what it says. Deliberate or reckless infliction of mental suffering, outrageous conduct. The conduct caused severe emotional distress, and the distress was severe. On the element of deliberate or reckless infliction of mental suffering.
And I covered this on today's
Liability
podcast
for
episode for
outrageous
those of you that
conduct,
have not
this is
seen
under
it
the
yet.
restatement.
We talk about these
Liability
elements of
for
the
outrageous
charge.
conduct arises
claim.
when the wrongdoer desires to inflict severe emotional distress, when that's the intentional part, or when the wrongdoer knows severe emotional distress is certain or substantially certain to result from his conduct. That's two. Or the third way is when the wrongdoer acts recklessly in deliberate disregard of the high degree of probability that emotional distress will follow. The reasonable inference from the allegations raised in the complaint is that the Laundries knew, and Mr. Bertolino knew, that Gabby was deceased. They knew the location of her body. They relayed that information to Mr. Bertolino. All the defendants knew that Joe Petito and Nicole Schmidt were desperately searching for their daughter. At the time that the September...
We got a really good question in the chat. All of them are really good, but I wanted to address this one because it matters right now to what's going on. So Casey Cat Lady asked, dumb question. No, it's not. What are the four corners of the complaint? They are arguing right now motions to dismiss. The standard for a motion to dismiss is whether within the pages of the complaint is sufficient to move forward. We've covered a lot of motions to dismiss on this channel, but it's not outside information. It is just whether within literally the four corners of the page, whether what's written on the pages is sufficient. So when they say the four corners of the document or four corners of the complaint, they literally mean within the paper. And the judge has to assume everything on the paper is true. And if the judge has to make any assumption, the assumption goes in the favor of the non-moving party, in this case, the Petitos. So they can only take it at the face of the document, and they have to assume everything in the document is true to rule on the motion to dismiss, which is why oftentimes motions to dismiss are lost. So that's not a dumb question at all. Never couch it with dumb question. It's just a question. Don't give it a judgment. It's helpful. I'm sure a lot of people had that question too. So always ask. It's helpful to let me know what you need explained. All right, let's keep going.
2021 statement was issued. And I would submit that the allegations are sufficient to support an inference that the defendants knew
Yes,
that the statement
the
was going
Laundries
to
and
inflict
Petito,
emotional
the
distress
Laundries
on the
and
parents,
Bertolino
or they
are
knew or
arguing
were substantially certain that
to
it would, or at the
dismiss.
very least, they acted recklessly
Two
in
motions.
deliberate disregard of a high probability that that statement would cause emotional distress to the Petito family. On the issue of outrageous conduct, I agree with what counsel had said. It's required to be so outrageous in character and so extreme in degree as to go beyond all bounds of decency. It requires an objective evaluation of the claimed misconduct to determine whether it is atrocious and utterly intolerable in a civilized community. And the burden does fall on the court. It's a question of law initially, not a question of fact. And generally, it is found where the recitation of the facts to the average member of the community would arouse his resentment against the actor and lead him to exclaim outrageous. The restatement provides a non-exclusive list of examples of what outrageous conduct is. Comment C in particular says, the law is still in a state of development. The ultimate limits of the tort are
Oh, this is a good question. We're not to the letter hearing yet. We're still in the motions to dismiss. So later today, we're in this now. We're in it. The judge was like 60 minutes and the lawyers are like each. So the letter will come up, it should be after this.
not yet determined. The caveat is intended to leave fully open the possibility of further development of the law and recognition of other situations in which liability may be imposed. It's instructive to look at the cases that I've cited in my brief where there has been conduct that's found to be outrageous and where it's been found not to be outrageous.
We live here today. Today we're in
Cases where
Florida.
it was found not to be outrageous in Williams versus
Feel the humidity.
Worldwide Flight Services. A former employee claimed that managers and some of his other supervisors had called him racial names, created a false record of disciplinary actions against him in order to terminate him. They didn't allow him to work with other African Americans. They put him out in extreme heat and cold to load and unload planes, threatened him with job termination, accused of him stealing, and had him move dangerous and heavy equipment and cargo and work extra flights so that he couldn't take his breaks. The court found that while the conduct was reprehensible, objectionable, and offensive, it did not rise to the level of outrageous behavior. In LeGrand versus Emmanuel, when 250 people were sitting in a church service, someone accused the minister of stealing money from the church to purchase a car. They called him Satan. They called him Macout, I think it's how it's pronounced, which is a name for the oppressive secret police from Haitian dictator Duvalier's regime.
What?
And they stated that his name means Satan. The court found that although they recognized
I did not
Brandon
have
defeat
Haitian
as being,
dictators on my bingo
certainly
card, y'all.
unsettling,
I did
embarrassing,
not.
and or humiliating, it doesn't rise to the level of being outrageous. And finally, in Duval Hotel Management, bride and groom had reserved a room for their wedding reception. The day of the reception, the manager of the hotel told them the room wasn't available, and so they'd have to have their reception in the lobby of the hotel, where there was not enough room for the 190 people, and during the reception, there were other guests walking through the wedding party. Some of them attended the party, and some of them were walking through in swim trunks. The court said the bait and switch pulled by the hotel
It's rude.
was not sufficiently outrageous to support a claim for intentional infliction of emotional distress.
Well, you can sue them
I'll
for
move on to
other
the cases where the
things.
court has found it. There was grounds for outrageous conduct and a claim for intentional infliction of emotional distress. In McAlpin versus Sokolay,
It's
a
very
woman went to a hospital because she had a
There were people in swim trunks at the wedding. That is a very different. That is a very different circumstance than here, counsel.
throat condition. She was disrobed, she had on a robe, and she was sitting in the x-ray room when a doctor came in unannounced and in the presence of other staff berated her for not paying another doctor's bill. He said he was going to call security and have her thrown out. She fled the room. She couldn't defend herself because of her throat condition. She fled the room, and the court found under those circumstances that there was reckless and outrageous conduct. In Nims versus Harrison, a teacher alleged that two of her students had written some sort of publication in which they used inappropriate, extremely offensive language about her. They threatened to kill her. They threatened to rape her and her children and her cousins. The court found on those grounds that's outrageous conduct.
What?
In Ford Motor Credit Company versus Sheehan, a collector on behalf of Ford Motor Company had been unable to find the debtor who was behind on payment for his car. The collector contacted the debtor's mother, claimed that she worked at a hospital and that two of the debtor's children had been involved in a car accident, and she needed to get in touch with him, so the mother provided contact information for her son. In the interim, the son contacted the mother. The mother told the son about the phone call she'd received. He spent 7 hours contacting hospitals and police departments to find out where his children were, only to find out that it was false. The court found in that instance that that was outrageous conduct.
I think that's
Dependable
also
Life Insurance Company of Harris.
illegal under a lot of the
The
collection
insurance
laws.
company was
In addition.
required to make car payments to a bank if the debtor became totally disabled, which he did. He made his application. The payments were made initially, but then they stopped. The claims manager on 2 occasions contacted the debtor, called him a fraud, and attempted to frighten him from collecting under the policy. His car was ultimately repossessed. He went into bankruptcy, and he suffered emotional distress. The court found that was sufficient to make a claim for outrageous behavior and intentional infliction of emotional distress. In Liberty Mutual Insurance Company versus Stedman, the insurer, this
This
was
is the
mentioned by, I
horrible
believe,
one.
Mr.
They're
Luca.
all horrible, but this is
The insured alleged that the insurance company
This is a
delayed
horrible
authorizing a double
factual
lung transplant, even though they'd been ordered to
scenario.
provide it, because they learned from the
Horrible.
decedent's doctor that she didn't have long to live, and if they waited this out, in their mind, if they waited it out, she'd die, and they'd not have to pay the cost for the for the
So guess what the
lung
insurance
transplant.
company chose?
The court found, and I think it's instructive in this case, the appellate court found that viewed in isolation, the conduct the insured had alleged with respect to the lung transplant is not so outrageous that it qualifies as atrocious and utterly intolerable in a civilized community. That's the position the defendants are taking in this case. The statement itself may be benign, taken in isolation. But the court considered,
Context.
however, paired with her specific allegation that the insurance company knew, based on testimony from the insured physicians, that she had a very limited life expectancy, and further considering that the insured was well aware that the clock was ticking, and that the additional emotional distress caused by the additional emotional distress caused by the delay could well hasten her demise.
Additional emotional distress is part of what he's arguing here, because the lawyer for Brian Laundrie's parents argued, look, we're missing elements of the crime. Because this is a murder case, my brain just goes to crime, but this is the civil case. These are charges and allegations, not charges. These are claims and allegations. But the reason this attorney is saying additional is because the attorney for the Laundries is arguing that the Petitos were already under distress. So Gabby Petito's parents were distressed given the nature of the circumstance. Therefore, there's no intentional infliction of emotional distress of anything the Laundries did because they were already so distressed by the circumstances. That's why he's pointing out these very particular words that matter. Additional distress, and this court holding and this case with the double lung transplant is one that the court cited previously and the judge cited previously. It's one of their cases that really is their holding case here. Okay, hopefully that helped. Let's keep going.
The court found the conduct fell within the ambit of comment F of the restatement. Comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly, I have trouble with that word as well, Mr. Luca, peculiarly susceptible to emotional distress.
Same.
By reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge where it would not be so if he did not know.
I am emotionally
That is our
drained.
allegation in this case. The statement's benign. Put it in
Are we still
context. Look at what they knew at the time the
Vanderpump tonight?
statement was
I'm
made. That's
not
what makes it
okay.
outrageous.
I need a margarita.
In Williams versus Mineola, another case that was cited to by Mr. Luca,
Warren, no, we're getting drinks tonight.
there was a drug overdose. The police officers took pictures of the
Before VPR.
decedent, went to a party, and then circulated and made jokes about it.
Which is
In
horrible.
determining whether the
That case, by the way, factually is pretty similar to the Kobe Bryant case. And this, again, additional distress. And that's why he's arguing these two case law points, additional distress. Judges make decisions based on what other judges have done. I'm inclined this way too. It's like, you want to find your new favorite drink at Starbucks, you ask people, what is your favorite drink? This is the same with judges. What have other judges done? What have other judges said? And they tend to go with the weight of the law of what other judges have done. That's why you hear so much citing of the case law, the facts of that, and why they are similar or distinguishable. Let's keep going.
And I will point out, by the way, in that case, the conduct was not directed at the party who was filing the lawsuit. This was something
was
that
at
was
the
done at the
party,
party and
right.
was discovered later on.
Right.
In
That's a
determining whether
good
the conduct of
distinction.
the officers was outrageous, the court stated, as for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida, show a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to family feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it is entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved.
That part of the court holding is very important to the Petito's case as it goes to the Laundries, and by extension, they're trying to bring in Bertolino on it. I think the motion to dismiss is harder with regard to Bertolino for the Petitos, but easier as to the Laundries. But the circumstance matters. So he is citing the case law to the court saying, look, in other circumstances, this might just be unenviable. It might just be ill-advised. It just might be objectionable. But given all of the circumstances, it becomes intolerable. This gets to the emotional infliction of emotional distress. So that.
Are already suffering physical trauma because of the loss of a loved one and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness, which might not be considered tortious in other situations, can show outrageousness and recklessness when a dead body or a picture of a dead body is involved. Finally, in the case of Thomas versus Hospital Board of Directors, the decedent died during hip surgery in a hospital, and the death resulted from the physician giving an overdose of a particular medication which caused cardiac arrest. The doctor and the staff inside the surgical suite decided that they were just going to simply say that she died as a result of the stress from the surgery.
Oh dear.
And that was, their report was issued, and an autopsy was not completed on the body for that reason.
Oh dear.
A week later, daughter of the decedent was burying her mother, and she, while doing so, received a phone call from the coroner saying she needed to immediately return the body back to the hospital so that a proper autopsy could be performed because he had learned of the real cause of death. The court found the decedent's daughter had sufficiently pled the elements of a cause of action for intentional emotional distress and said, as noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress, the actor's conduct may become heartless, flagrant, and outrageous. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage.
The false information is going to be the factual scenario here, but that is not an argument for motion to dismiss. That will come on motion for summary judgment. So what he's saying is, under the law, there is enough on this complaint to survive the motion to dismiss. And that's important here. And I think the false information is different. Was given the false information in that case, or finding out that false information was given, what caused the distress? I think that case is similar to this case. So these cases allow the Petitos to argue that there is enough legally to survive the motion to dismiss. Summary judgment's different. The court starts making factual determinations. Here it is taking all these things as true.
Like the last two cases, the Thomas case and the Williams case, we're dealing with a person. We're dealing with someone who was deceased. And we're dealing with parents who were incredibly vulnerable because of the fact that their daughter was missing and they didn't know where she was.
But they
And
did
I
not
think
know she
this
was
falls
deceased
within
yet.
those types of cases where, as was noted, I think in the Williams case, special deference is paid by courts to family feelings where the rights of dead bodies are concerned. Comment F, which I already spoke to comment F. At the time the statements were made, according to the allegations of the complaint, which the court must accept as true and which the court must draw all reasonable inferences from, the defendants were aware of the vulnerability of Joseph Petito and of Nicole Schmidt to emotional distress because of the uncertainty of where Gabby was or if she was even alive at the time the statements were made by Mr. Bertolino. The conduct of the defendants became heartless, flagrant, and outrageous.
I don't know how it will fly to
when the statements
Bertolino.
were made in the face of such knowledge, where otherwise the statements would not have been so outrageous or heartless or flagrant. At this stage, it's not the plaintiff's burden to prove the allegations of the complaint. The question is whether the allegations as pled are sufficient to make out a cause of action, and I would submit that they are. Comment E to the
He's argued the
restatement
case
also
law well
says,
too.
in support of the outrageousness requirement, an unequal position of the parties in a relationship where one asserts power to affect the interest of the other may supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Again, the defendants knew that Gabby was deceased. They knew where her body was, according to the allegations of the complaint. They knew that the Petito family was desperate and upset. And had they just kept quiet, we wouldn't be here. If they had kept that knowledge to
They
themselves,
couldn't have sued.
we wouldn't be here. We wouldn't be standing before you having this argument.
Well, you
But they
couldn't.
didn't just keep quiet. Instead,
true.
with that unequal position in which they stood vis-a-vis the Petito family, they made that statement of hope. And they knew, or they should have known, that that would affect Joe Petito and Nicole Schmidt and cause emotional distress. Defendants suggest somehow that looking at the full statement from September 14 of 2021 will make a difference in the court's determination of whether or not there's outrageous conduct. The first paragraph and the third paragraphs simply say it's a difficult time for both parties and the Laundries are going to keep quiet. That does not in any way soften the blow of the content of the second paragraph. I'm frankly surprised that both defendants have suggested that the term reunited is subject to interpretation. They suggest it could mean the person is not alive, and they cited to various articles in which remains were reunited with a family. But the statement doesn't say, we hope the remains of Gabby Petito are reunited with her family. It says, we hope the search for Miss Petito, not her remains or her body, is successful and that Miss Petito, not her remains and body, are reunited with her family. Frankly, I think the defendant should be embarrassed for raising such a ludicrous interpretation of their own words.
There's the fire.
And by the way, if those words are subject to various interpretations, that's left to the jury to decide what it means based on credibility determinations.
We go to summary
We believe
judgment
the
first, but
allegations
yes.
clearly satisfy the requirement of setting forth a factual basis for outrageous conduct. And I cited the court to the Williams case where it said if differing inferences can reasonably be derived from the
I like
facts
the way
alleged,
this attorney argues
the question
too.
of outrageousness is for
I
the
like
jury.
him, and I like Bertolino's attorney.
Move on to the
quite a
suggestion
lot.
that Mr. Bertolino's statements are protected. I would agree,
Laundrie's
as they
attorney
said,
is at the
that a statement made by
bottom
the
of that
defendants, although extreme
me.
and outrageous, may be privileged under certain circumstances, but there are no such circumstances in this instance.
They took
As
shots
the
at him, so I'm
court
not surprised he's
pointed
taking
out,
shots
the
back.
ABA model rule of professional conduct is not binding on any, don't even know if
He's
if it
like-
applies. It's a model rule.
What the fuck does it matter?
But suppose it is something that we should consider. It says an attorney may, doesn't say shall, doesn't say must, an attorney may make a statement to
May.
protect the client from adverse publicity.
May is
And
very
in making that
interesting
argument, the
language.
defendants go outside the four corners of the complaint. They suggest that
Fair argument.
Brian Laundrie and Roberta Laundrie and Christopher Laundrie received a great deal of publicity, that statements were being made about them, and that Attorney Bertolino had a right and duty to protect his.
Oh, there was lots of publicity surrounding the Laundries. Yes, yes. Yes, yes, there was. I love that he's taking the opportunity to be like, well, even though they went outside the four corners of the document, let me just address it real quick to have a moment to say what I want to say. And this was the Laundrie's attorney that brought it up. So he's hitting it. He's hitting it back.
Clients from prejudicial effect of that publicity. Well, that's not what the ABA standard says.
And
It
they
doesn't
weren't
say
on
he has a
trial.
right and duty.
And there was no litigation pending as to
But
them.
none of this is referenced. This publicity is nowhere within the four corners of the complaint.
Correct.
And more importantly, looking at that statement, if that's what Mr. Bertolino's intention was at the time he issued that statement, how does a statement expressing hope that Gabby Petito is reunited with her family, how does that protect his client? If he wanted to protect his client, he should have disclosed where Gabby was. Even if he had a right under those circumstances
He's
to
like,
make that statement
don't
on
think
behalf of his
so.
clients, it didn't give him carte blanche to cause
Correct.
emotional distress, nor does it give him immunity from liability for issuing the statements. It simply says he can make them. It doesn't say under all circumstances he has that right. As far as the litigation
Okay.
privilege, it does exist in Florida to a degree. It allows litigants and counsel to zealously advocate positions in court.
In
Defendants
court.
suggest, again, going outside the four corners of the complaint, that statements were made. At the time the statements were made, there was
The
intense
shade.
law enforcement and media investigation. I'm not sure how you find that in the complaint, but they say the only reasonable inference
It's
to be
not in
drawn
court.
is that the Laundries faced a criminal
Excuse
investigation
me.
and media inquiries.
They didn't face.
Well, I don't know that
They're not
there
in
is any
court?
law that says reasonable inferences must be drawn in favor of the defendant.
There isn't.
It says in favor of the plaintiff.
There is.
They state that
Agreed.
based upon the fact that there was a potential criminal investigation, Mr. Laundrie has a litigation privilege. Mr. Bertolino has a litigation privilege to make that statement. It's not reasonable to suggest or to
I didn't
infer that the
no.
Laundries were the subject of an investigation, although it would be with regard to Brian Laundrie.
Yes.
Unless Christopher Laundrie and Roberta Laundrie committed a crime that we're unaware of.
This attorney's like, so counsel, is what you're saying to me that you have a litigation privilege because your clients, the Laundrie parents, committed a crime? What was that crime? Aiding and abetting after the fact, perhaps? I don't know. Is that what, Your Honor, is counsel trying to say that his clients committed a crime and therefore litigation privilege applied? Is that what they really want to argue? Counsel, we see you. We appreciate the shade. You're also easy to follow and it doesn't feel like we're being yelled at. So, would recommend.
Arco case that was
Bertolino's like,
in
no,
reference by
no,
Attorney
no.
Luca, when it talks about the absolute privilege, says the
I like
absolute
these
privilege,
arguments.
Supreme
I like
Court,
the reading
Florida Supreme
glasses.
Court
I'm
has
here for it.
explained, is part of a trade-off. The absolute privilege was created to encourage zealous representation and the free and full discovery of facts between the parties and the court.
And there was
This
no
absolute immunity resulted from the balancing of two
litigation.
competing interests: the right of the individual to enjoy a reputation unimpaired by defamatory attacks versus the right of the public interest to a free and full disclosure of facts in the conduct of judicial proceedings. The
Also,
question
this guy's
here
at
is,
1.25, so
what was
he
the
is
judicial
speaking
proceeding?
in a measured way.
What proceeding was going on? What proceeding was anticipated at the time
Yes!
that he made these statements?
That's what we said.
We don't know. There isn't one.
That's what we said. That's what we know.
And the statement has to be made in context of those proceedings, and that's the Ball versus D. Lights Enterprises, which I cited in my response. This, if they're
Not
suggesting
like Groove is in the heart,
statement was made in
right?
reference to this particular litigation, it wasn't even contemplated at that point in time. Absolute immunity does not apply or include a publication of a defamatory matter. This is the Ball to Lights case.
This is him just
Does not apply to or
distinguishing the
include
two
publication of
because litigation
defamatory matter
privilege
before
does
the
not
commencement,
apply
before
here.
the commencement, or after the termination of the judicial proceeding, unless such publication is an act incidental to the proper initiation thereof, or given legal effect thereto. Nor does it apply to include any publication of defamatory matter to any person other than those to whom, or in any place other than which, such publication is required or authorized by law to be made for the proper conduct of judicial proceedings. Again, what judicial proceedings were undergoing at that point in time. The statements must be made, according to the Arco Plumbing case, which I cited in my motion, the statements must be made to the court, to parties, to law enforcement, or witnesses. Arco Plumbing, that's the Arco Plumbing case. In this instance, the statement was made to the press, directed to Joseph
Right.
Petito,
Not-
Nicole Schmidt, and the entire Petito family.
Right. Not
That's
in
admitted
litigation.
by Mr. Bertolino in his motion to dismiss. In Buckley versus Fitzsimmons, which I also cited in my response, the court held statements at a press conference do not have any functional tie to a judicial proceeding. They also suggest they might have a qualified privilege, but that's only available when statements are made to police during a criminal investigation, and that was set forth in the Delmonico
Not the case here.
Mr. Bertolino cites to the Orange Lace Country Club case.
Does not apply.
But the court stated that
Does
statements
not
necessarily
apply.
preliminary to judicial proceedings
Does not
include
apply.
pre-suit communications required by statute or by contract as a condition to suit. There is no contractual or statutory obligation which would apply here. The defendants have suggested that there's an issue with causation.
They have
And they
suggested
suggest
that.
that perhaps there's no discussion of causation in the complaint, but paragraph 40 of the complaint
Your
clearly
Honor,
says
I would like
the
to point
emotional
to-
distress was caused by the statements made by Mr. Bertolino.
And the Laundries?
They also suggest that the statements must be the sole cause of the emotional distress, and they cited the court to the standard jury instruction in civil cases 410.6, but they only told you about subsection A,
Ooh.
not subsection B, which says, defines a concurring cause. And this is in the instruction for intentional infliction of emotional
Wait,
distress.
there's a concurring cause
In order to be
instruction?
regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. It may be a cause even though it operates in combination with the act of another, if the extreme and outrageous conduct contributes substantially to producing such emotional distress. That's what we have in this case. In this instance, we have
there's
a
that.
family undergoing
Contributing.
distress, wanting to know where their daughter was. She hasn't
subsection
contacted them in a
B.
long time.
gonna
And
get
along
ya.
comes this statement made by Mr. Bertolino, and the statement we would submit is a concurring cause of the emotional distress. Restatement,
Puddle gum.
the comment
Puddle
J to
gum,
the
we're gonna get
restatement
there.
says,
We're going to get there.
severe distress must be proved, but
Burn
in
after
many
reading
cases,
letter.
the extreme and outrageous character of the defendant's conduct is in itself important evidence that the distress existed. The allegations of the complaint show the conduct itself the nature of the conduct itself fits within comment J because it's so extreme and outrageous. Knowing someone has passed away, knowing a family is grieving to express false hope that she may still be alive is outrageous.
This whole case is going to come down to hopes and prayers.
Attorney Luca also discussed the
We're
issue of
still waiting
agency.
for the court to decide the
It's an
motions
interesting
to
argument in which
dismiss
the Laundrie seek
before we get
distance
to burn
himself
after
from Mr.
reading.
Bertolino by suggesting that
But I like the way this attorney
because
argues.
the complaint alleges malice, he was
I liked
acting alone,
Bertolino's
not on
lawyer,
behalf of
too.
the Laundries. But as Judge Carroll noted in his opinion, an attorney's acts are the acts of the principal, the client. And that's the Stinson versus Pravat case, where the court said the principal is
The
liable
Laundries are not in
if
court.
the wrongful
Their
act is done
attorneys
while
are.
the agent is acting within the scope of his apparent authority, even though the act was not authorized by or was forbidden by the employer. or was not necessary or appropriate to serve the interest of the employer unless the act was done to accomplish his own purposes as distinct from the employer's business. That sounds more like an affirmative
Chrissy
defense to be
D,
raised
just
or an
keep-
argument to
just
make-
hang in
be
there with
made at a
us.
later time that,
Wait till we get to the argument
that he
about the
wasn't
letter.
acting on behalf, that Mr. Bertolino was not acting on behalf of
The
Laundries
letter
when he made
matters
that
here.
statement. But within the four corners of the complaint, there's nothing to support that argument. In fact, the statements themselves issued by Mr. Bertolino say "we" and "our." In sum, I would submit to
very
the
good
court-
point.
Well, I do want to address two other issues that were raised. I apologize.
Though I do say we to mean us, all of the law nerds, though I do not legally accept responsibility for
I
it.
believe I've addressed them. In sum, I would submit that, just as Judge Carroll found, the allegations of the Second Amendment complaint are sufficient to set forth a cause of action for intentional infliction of emotional distress, and both motions to dismiss filed by the defendants should be denied.
Thank you, counsel.
Mr. Riley, I do have
Yes.
a question for you. If you look at, for paragraph 40
Of the complaint?
of the complaining,
Of the
yes,
complaining.
complaint, paragraph 40, subsection A and B.
I'm sorry, Your Honor, but thank you. We now have exhibitees and complainies. I swear she said complainy. I'm going to just back up. I love covering this a little bit on delay because in motion hearings like this, it's funny, but complainy is my new favorite thing. It's hard. Look, I could never be a judge. The amount that my brain would check out sitting here listening to these lawyers without talking to all of you, I couldn't handle it. Complainies and exhibitees.
If you look at, for paragraph 40
Of the complaint?
of the complaining, yes, of the complaint, paragraph 40.
I like that
subsection
40
A
and complaint merged to give us
begin your
complainy.
argument Indicating that this is not about,
Motion granted.
This is not a
Complainy is
silence
now in the
case.
vernacular.
this is about statements made.
And Judge, I'll agree to strike those two paragraphs. They shouldn't
What?
be there. I agree.
Okay.
We're not, this cause of action is not based upon their silence.
So then you will strike A and B, C, D.
Oh,
Yes, I'm not going to take out the factual allegations earlier where that was said, because in my view, that shows a
That,
course of
that
conduct.
shows the context,
Right.
Right.
but I do recognize Mr. Metz's point in that because we don't have specific, to each of these counts, we don't have a specific title for the count. It would,
right.
the complaint is intended on making sure that we understand which statements we're actually talking about. And I
Right.
also recognize in your complaint in paragraph 33,
Right.
where it says, with regard to Mr. Bertolino, he released numerous other statements regarding Christopher Laundrie, Roberta Laundrie, and O'Brien Laundrie to the national press and to the Florida,
All
and to
fair.
Florida in particular, while Mr. Metz kind of breezed by that as far as a jurisdictional statement. Are these statements that you're also indicating
No,
could have
no,
caused?
that was purely for jurisdictional.
Okay,
reasons.
so therefore, the statements that we are talking about here are specifically
Those
the
are jurisdictional.
statement of
Good to know.
of hope that was done at, that we've talked about ad nauseum here.
Yes,
And then the prayer statement,
yes,
and then that's it.
yes.
Okay,
Okay.
all right. Thank you.
Thank you.
You guys, thank you again for making this the #1 place to watch live court coverage. I appreciate you. Don't forget to do the YouTube things. Are you prepared to rule? Say you're prepared to
You
rule.
all know that I'm going to reserve on this particular issue.
No! Okay, well, now we'll get to the other motion. The court's not ruling on this today. I said that to JB earlier that the court would reserve. The court is reserving. What does that mean? It means the court's going to rule on this later by written motion. The court has heard everything and the court is going to issue a written order later. All right. Let's get to the burn after reading letter. Let's rehype ourselves.
The motions to dismiss. For you all shortly with regard to those. We do have two other issues that we need to address. Oh,
Judge, I maybe had a rebuttal I could do in 1 minute.
No, you
1
can't.
minute.
Yeah.
Yes, you can give me a rebuttal.
The fuck you can. Okay, you probably
The,
can. We like you.
The trial attorney that comes up for cross-examination says I have one more question.
I like this, Judge.
Judge, I gave a closing once in 22 minutes for a 4.5-week trial, so I'm going to do this.
Really?
Paragraph
Go ahead and flex, counsel. I don't know. He's like, I can get it done quickly. I don't know if that's the flex you think it is, but 22 minutes is fast. He's like, I can get to the point. I actually think this attorney can get to the point. I really liked his arguments earlier.
40 doesn't talk about causation. So Mr. Riley said it did. It doesn't, and causation is missing throughout.
Okay, that's
Mr.
fair.
Riley talked about recklessness. Count 3 and count 6 does not raise recklessness. It raises willfulness and maliciousness. There are 4 elements to intentional infliction of emotional distress. At best, Judge Carroll
My
partially
notes have
commented
gotten
on
very
one of them.
messy.
You take those 4 elements as a checklist, and you read through this complaint, and you read through all of the counts, you're not going to check all 4 off.
Counsel, I think that was more than a
It doesn't
minute.
set forth a cause of action for intentional infliction of emotional distress. It doesn't have all the elements. And that's within the 4 corners. And for this type of claim in particular, your role, and what the courts have said are your responsibilities. And
I don't know if that was Gabby Petito's father or the lawyer who said, that's a minute. I think so too. But I'm time blind. What do I know?
the scope of what you can rule on clearly puts you as the gatekeeper for this. And there's not sufficient evidence for it to move beyond this point.
Well, the court's going to
Thank
give you a written ruling, so you're going to have to wait on it.
20 seconds.
They timed him 1 minute, 20 seconds. Here's the thing. They wanted to do the motions to dismiss first because if the court was going to go ahead and dismiss it, it might shift the ruling on the letter. I don't know if the court, if this indicates the court's going to reserve the ruling on that until after the ruling on the motion to dismiss, because we have a cart horse situation. Because if it gets dismissed, the ruling on the letter, you know, if it gets dismissed, then you can't really demand the letter gets turned over. So I worry we're not going to get a ruling on that either. All right, let's keep going.
Anything else you wanted to add?
Your Honor,
Very
I'm sure everybody would appreciate it if I didn't speak.
Yes!
Again, but I would
Accurate.
just ask
Thank
the
you
court
for
to
the
consider.
self-awareness.
I know Mr. Metz mentioned that counts 3 and 6 had the willfulness, maliciousness language as opposed to deliberate and reckless. It's the same for all the counts against all of the defendants.
Okay,
So to
great.
the extent that you're considering that argument, that applies. It wasn't just for the counts that applied to his.
KK.
All right.
Cool.
So I'm going to be reserving on that ruling. The rebuttal has not made me change my mind on that. I'm going to be reserving, and we've got our next issue. What would y'all like to handle next? gentlemen?
Burn after reading.
We could do the easy one, which is the third request for production of documents where I asked for any account statements which showed transactions in excess of $10,000.
That's fair.
Mr. Lupin has indicated that all those transactions were for payment to Mr. Bertolino, and that he was satisfied to have the court take a look at it and determine if he's correct, and I'm fine with that as well. If the court looks at it and says there's no
That is
withdrawals or
easy.
transfers in excess of $10,000 that went to anyone, that didn't go to anyone other than Mr. Bertolino, then that satisfies my inquiry in that area.
Okay, and I looked at that earlier today.
Okay. Then we'll get to the letter.
Hey, Judge, these motions don't involve me. Would you mind if I stepped out briefly? Came
Sure,
back.
absolutely.
Counsel's like, can I not be subject to counsel for a minute? That's funny. He's like, I need to make a call, go to the bathroom, grab a snacky snack. I don't know what's happening.
I've got copies of the records if you wanted to.
Okay,
take a look at
because you
them.
gave me, I
did.
that I have the,
I got them here if it's easier.
Is that it? That looks like 4 pages.
I've got it right here in front of me.
Okay.
unless
That's
it's different.
very brief.
You know, Your Honor, I don't know if we included this one because I don't know if I had it at the time. This sort of explains, this is just a check, it sort of explains like one of the entries.
Oh, okay.
Tara, I love y'all too.
So,
We all want
Your
the
Honor,
same thing. We're ready.
So if we look at these records,
Tell us about the bank records.
first of all,
Sure.
when we're talking about transfers, I know Mr. Riley said that he wasn't interested in payments to Mr. Bertolino. There is a payment that's from Mr. Bertolino too.
Wait,
So
what?
Let me,
What?
if I could just explain
What,
the
what,
records.
what?
This might.
Why is Bertolino paying them?
Okay.
Is he refund? Is that a refund on the retainer for Brian Laundrie after they knew Brian Laundrie was deceased? I have questions. Why is Bertolino paying the Laundries? Okay, here's what's happening. Let's swoop real quick. We've moved into a different motion. My computer is just, it's struggling like my brain. I'm ready for Vanderpump reunion. I get it. You are too. Let's swoop. I pushed the button and then the swoop is. Here's what's happening. We are moving on to the third of 4 motions. This is a motion with regard to a request for discovery from Gabby Petito's parents to the Laundrie's parents. They are asking for any bank transactions over $10,000. What has happened is they have asked the court to review the bank records during a fixed period of time to say, hey, during this period of time, were there any transactions above $10,000? Why that matters to them, why $10,000 is the thing, don't know. We'll read the motions later. But what the attorney has represented is that the transactions are either from the Laundries to Mr. Bertolino or Bertolino to the Laundries, and payments to lawyers are not going to be discoverable to them. So they've all agreed that the court can look at the financial records and determine if there's anything else in the financial records that need to be disclosed. This should be very quick as the court takes a look at it, and we should hear if there are or are not any, but the court can look at it to see. So why Bertolino might have paid back the Laundries, the timing of that is very interesting, because if the Laundries originally hired Bertolino to represent Brian, A, when did that happen? B, why? C, does that go to indicate that they knew that Brian Laundrie had killed Gabby Petito when they hired an attorney? Or is it just that they knew that there was a police inquiry and that's why they hired him? So there's a question there. But was he refunding them because they knew that Brian Laundrie was deceased? What day did that happen? Was it before he was found? So there's some questions there on timing, but that's what they're asking the court to look at, the financials, to try to see what was happening. Oh, yes, this is probably a very good point in the chat, maybe to see if they were trying to help him flee the country. Pause and Fins, you make an excellent point. Thank you. I'm trying to pull that up. My computer is going slow today. Thank you. All right, let's continue with this. This should go quick.
If you look on, so one page of the bank statement is for a checking account and one page is for a savings account.
I'm glad I get to spend the day with you.
So if you look on September 1st, there's a fairly large deposit. And that deposit corresponds from that check from the law firm. That's a law firm that's associated with Mr. Bertolino. So that's what that check is. Then that amount of money is transferred from the savings account to the checking account. And then about a week later,
We're learning more things.
there's a check that's written to Mr. Bertolino. So
For far less.
for far less, yes. But then the remainder of the money just stays in the checking account. And so, Your Honor, the payment that came in, the deposit, was for like a business transaction, totally unrelated to anything in this case. And you'll see that the check that was deposited is actually dated August 13th. So it would be outside of Mr. Riley's third request for production, outside that date range, and also would have predated anything that would have happened between Brian and Gabby.
So I'm not interested in that. I know what that is, and I'm not interested.
Okay, so then the only other transaction would be the payment, the check to Mr. Bertolino about a week after that.
Okay. If you just give me 1 second, because I want to specifically look at the production request, and then I can affirmatively tell Mr. Riley that you have given him everything he needs or not.
So I haven't given him these records, because again, they don't meet with.
I know, but what I'm going to look at his request, specifically look at his request, look at what you've given me, and then tell him he doesn't have to give them to you, or he does.
Okay.
Okay.
And it's request number.
Good.
It's the third request for production. I
Third
believe
request.
it's the only request within that
Oh,
production.
They've done a good job with that. So they're going through, the court's going through and looking at the records to determine this now. I'm going to zoom us a little bit because
2021 through September 14th.
the court's reviewing to make a ruling on this. And I'm going to speed us up just to catch us through this time while the court's doing it so we don't miss anything. I'm going to answer some questions as well while we're doing this. Kate P said, question, if the lawyer isn't licensed in the jurisdiction, does that mean he can't act in the position of a lawyer and therefore isn't protected by litigation privilege? No, the litigation privilege is a separate issue. He can act as their lawyer in making public statements to the media and representing their interest and advising them. He can't go into court for them. So it's
On these records,
Two issues.
None of this would comply with your request.
Okay.
okay.
That's fine.
There's nothing discoverable.
So, then as far as the motion to compel, based on my in-camera review, I'm going to be denying the motion to compel.
Okay.
And
Normal
would you
speed's too
prepare an
slow.
order for that?
Yes, thank you, Your Honor.
Wonderful.
I need a sledgehammer. Sledge.
Just to make sure that it doesn't end
Sledge.
up out in the world, I'm going to give you this back.
CEG. Okay. That's very conscientious of the court. So this doesn't end up in the world. I'm giving this back. This is not discoverable. I was talking about the song Sledgehammer quite a lot yesterday. And it came up.
Additional motion that we have to take care of.
Yes!
Yes, Your Honor, the only remaining motion is the motion for protective order.
Burn after reading!
And this relates to the letter that was
Burn
authored by
after
Bertolino, which we
reading.
discussed, I believe, at our last case management conference.
Yes, sir.
So this is just the motion that now brings it before.
Swoop, swoop. We're going to swoop. We are moving on. We are moving on. Let me try to swoop a doop for us. We are moving on to the fourth and final motion of today's motion hearings. We have heard two motions to dismiss, one from the Laundries, one from Mr. Bertolino. The court has taken that under advisement or a reserved ruling on it, meaning the court will rule in a written ruling later. Now, then we heard a motion for discovery, a third request for production. The court reviewed bank records and said there's nothing discoverable here, gave the record back to the attorney so it didn't find its way out into the world, is what the court said, and then ruled on that. Nothing discoverable in that request for production. And then, oh, hey, Trav, you scared the ever-living life out of me. Glad you're home. Hi. What? Thank you. Glad you're home. So then we are getting into the burn after reading motion. This is a defense motion for protective order. The defense is asking that a letter from Roberta Laundrie does not get turned over to the Petitos. The Petitos have said, we've seen the letter. We want the letter turned over. And oh, by the way, the letter is undated. And in it, Roberta Laundrie, the mother, says to Brian Laundrie, her son, that I will bring a shovel to help bury a body and something about baking a cake with a shiv in it in case Brian Laundrie goes to prison. That is in this letter. The letter is found in an envelope that says burn after reading. The letter was turned back over to Stephen Bertolino by the FBI. The Petitos have also seen it, probably through law enforcement, but they want to get it in discovery. This letter is a big deal. If you did not listen to today's podcast, after this, go listen. The audio or the video. It's up to you. It's on your favorite podcasting app. It's the Emily Show. It's great. So this is the hearing I have been waiting for since we started streaming like 2 hours ago, because 2 hours and 45 minutes ago, because this hearing is a very big deal. This letter getting turned over into discovery is a very big deal. And I worry that the court's going to reserve ruling on this, but this is a big deal. I covered in the podcast, I covered Roberta Laundrie's affidavit about this. The first time we've heard Roberta Laundrie say anything about this case in a written affidavit. I covered what we learned. Woo! This one's crazy. This one matters. This is a game changer if this case goes to trial. And that's why they are fighting for a protective order to not turn this discovery over. So that's where we're at right now. Let's go.
For the court.
Okay. And if you would like to, it's your motion for protective order, so if you'd like to get us started.
Thank you, Your Honor.
All right. I want to know
Your
what
Honor,
you have
we
to say,
filed
sir.
an affidavit of Mrs. Laundrie explaining
Yes, you did.
her authoring the letter and the purpose of the letter. Her affidavit explains that she wrote the letter to Brian and never intended for anyone else to see it. She wrote it prior to Brian and Gabby leaving.
Chat. What have we learned from the cases I have covered? Things you intend the public to never see may be seen. And lawyers will try to skew them one way or the other. We saw this in Depp v. Heard with Rottenborn going, did you say you have other uses for her throat? Texts that people never thought would see the light of day. If you say it, write it, note it down. If you look, the internet's trying to make it so if you think it, you'll be punished for it, even if they can't prove that you thought it. But that's different. Things will see the light of day. We don't know when Roberta Laundrie wrote this. If it is true, arguendo, that this was written before any of this happened, then the timing is extraordinarily unfortunate. And I have to ask, what Roberta Laundrie has done to like raise the wrath of like, I don't know, AWA or the Force or whatever for this to happen. So, yes, she did tell him to burn it after reading. She thought it would not see the light of day, but here we are. The prison comment, if accurate as stated in the legal filings, seems to indicate that maybe this was written after, but I want to know where it's found. All right, so now this is the moment we've been waiting for. Let's go.
For their trip. So it does not relate to any of the events that occurred thereafter. Her choice
Says you.
choice of words in hindsight are unfortunate, but that doesn't mean that the letter is relevant. Plaintiffs argue that Mrs. Laundrie's affidavit is a self-serving statement of a party.
It is!
So the court should disregard it. Of course, the plaintiffs don't offer anything that contradicts Mrs. Laundrie's affidavit other than that.
Well, they don't have the letter yet.
This was a private note between a mother and a son.
Oh, they're
They would have
laughing.
been the only people to know the circumstances regarding its creation.
And he's dead.
Mrs. Laundrie is the only person who can comment on it at this point. Now, the letter is undated.
At this point, at any point. Roberta Laundrie is the only person who can ever comment on it because Brian Laundrie is deceased. So, you know.
Although she wrote the letter because she and Brian were experiencing a difficult period in their relationship. And he was about to leave home. He was about to go on this long trip with Gabby. And she was hoping to repair their relationship before he left.
Ah! I just screwed it up. Hold on. I've messed things up. Oh, Emily. Tech. I'm sorry if I scared you. By squealing. I apologize. I can't believe he's making this argument. We've seen the Laundries laughing. Hold on. I'm going to catch back up. I'm almost there.
About a week after that.
Okay.
All right, hold on. I'm sorry, y'all. I'm sorry. Miguelina, just whap us while I find this, if you don't mind. I'll grab my fan in a second. I'm trying to find our place. We are professionals here. All right. I'm still trying to catch us back up to this attorney. Wrong attorney. Not that attorney. I'm sorry, y'all. Intermission. I was trying to get to the Petitos laughing at this argument. And this is...
That he wasn't acting on behalf, that Mr. Bertolino was not acting on behalf.
This, I backed up. We've gone too far. We've flown too close to the sun.
That's kind of breezed by that as far as a jurisdictional statement.
All right, wait, no. This is... I forgot where we were. Timing-wise. Okay, we've gotten way too far back. Sorry, y'all. We were getting to the end of this. And I think we are almost to where we need to be.
There's no withdrawals or transfers.
Okay, we're getting closer to where we need to be. Apologies.
So that's what that.
All right, those are the finances. This is why we put timestamps down below for the replay crew. Replay crew, love you. Sometimes live streaming's dynamic. I apologize.
Would comply with your request.
Okay, I'm satisfied.
Thank you.
All right, we're almost there.
So,
I'm gonna scoot it so I don't screw it up.
But that doesn't mean that the letter is relevant.
Okay,
Plaintiffs argue in hindsight are unfortunate
there we go.
events that occurred thereafter.
Thanks, Chad.
Her choice of words in hindsight are unfortunate, but that doesn't mean that the letter is relevant.
They're unenviable for sure.
Plaintiffs argue that Mrs. Laundrie's affidavit is a self-serving statement of a party, so the court should disregard it. Of course, the plaintiffs don't offer anything that contradicts Mrs. Laundrie's affidavit other than that argument. This was a private note between a mother and a son. They would have been the only people to know the circumstances regarding its creation. Mrs. Laundrie is the only person who can comment at this point. Now, the letter is undated, although she wrote the letter because she and Brian were experiencing a difficult period in their
Here's what
relationship.
I wanted to pause and talk
he was
about.
about to leave.
I have to wonder if the Laundries, the family, the parents, were fighting with Brian over going on this road trip with Gabby. Because Roberta's affidavit says that their relationship was great until he was getting ready to leave for this trip. What was it about this trip that was causing a problem? And were they fighting over him going away on this trip with his fiance? I have a lot of questions about this.
Home. He was about to go on this long trip with Gabby. And she was hoping to repair their relationship before he left.
If I'm trying to repair my relationship with my kid, I'm going to say, let's, do you want to watch anime and like make dinner? Do you want to sit down and play Mario Party? That would be my youngest. Like, what can we do to bond? What I'm not going to say is let me put a shiv in a cake in case you go to prison. Those things are very different to me. Like, let's sit and watch Arcane. Let's a movie. I've got questions.
Now, there are several contextual clues within the letter demonstrating that it was written before Brian's trip. And Your
Just read the letter. Read the letter into the record. Oh, please, God. Read the letter into the record. Give us the context.
Honor, I did provide you with a copy of the letter, I believe. So first, Your Honor, the letter doesn't mention Gabby at all.
Judge, how can I respond to this if I don't see the letter?
Yes.
It is.
Well, first of all, Your Honor, I would note that
Your Honor, how can I respond? I can't do my assignment if she didn't do her assignment. She's talking about some garden party. This is the argument here. Oh, spicy.
Mr. Riley has seen the letter.
I don't, that was well over a year ago, and I don't have.
He has a point.
Okay, so I understand.
With the contextual clues, it's hard to give context. I mean, with the last.
Give him the letter, and we can all
the last
argue.
motion that we had, that's an easy thing for me to look at, and hopefully Mr. Riley to trust that I can read a bank statement and say, hey, there's none of these things that you're asking for in it. But this is, you're asking me to make an interpretation.
Correct.
And that, I think.
Is for a motion
due
in
process
limine.
would permit him to be able to argue that.
Understood, Your Honor, understood.
Correct, Your Honor.
So
Correct.
let me just bypass then referencing any of the content of the letter.
All right.
Yeah, well, you can't have it both ways, counsel. Either bring the letter or argue why you can't bring the letter. I think this letter is getting turned over, and then you argue this in a motion in limine. I think you're putting the cart before the horse.
So going back, Your Honor, we have provided this affidavit from Mrs. Laundrie that explains the context in which
self-serving
she
one?
wrote the letter. And the plaintiffs certainly don't offer any evidence or any contrary affidavits that Mrs. Laundrie's affidavit is
They've argued
incorrect,
it's self-serving.
or any other information regarding why the letter was authored, when it was authored, any of those details. They simply call it a self-serving attempt to withhold a key piece of evidence. And this leads me to my next point, Your Honor. This letter is not a key piece of evidence. It was a private note between a mother and son. The plaintiffs never saw it. The letter has not caused them any emotional distress.
You're missing the point. The letter doesn't have to, I'm now arguing with him. The letter doesn't have to cause emotional distress. The letter gives context to whether or not they knew that Gabby Petito was dead at the time that the statement was made by Stephen Bertolino. That's why you have missed the point, sir.
And
Did you bring enough for the class?
The plaintiffs haven't demonstrated that the letter had any connection to Mr. Bertolino's statement, which is the foundation of their entire claim. Now, the plaintiffs cite to HEPCO Data LLC versus HEPCO Medical, 301 406. It's a Florida 2nd DCA case from 2020. And also to Dees versus Kidney Group and Kiker versus Lopez. Those sites, again, are in their motion. For the argument that irrelevancy is not a proper ground for protective relief under Rule 1.280 Section 6.
That's for your motions in
Now, Your
limine.
Honor, I believe that misreads the point that those cases were making, which is that for a protective order,
Misstates?
there has to be something in addition to relevance as an objection. There must also be a showing of annoyance, embarrassment, oppression, undue
annoyed.
burden, or expense. In other words, relevance is not enough. For example, the Dees case that the plaintiff cite said, the protective order prevents any discovery concerning two prior clients and a new venture formed by the other two members of the company.
I don't think-
the information appears
I don't think you're gonna
relevant
get
to
this
Dees' claim
protected, sir.
or reasonably calculated to lead to the discovery of admissible evidence.
Motions
Again, so the
in
Dees court
limine.
considered relevancy. It was just that you needed to go that extra step about showing embarrassment or oppression, undue burden, or expense.
Yeah, this letter matters a lot. This is why they're
And, Your Honor,
fighting
we've
it.
cited to a number of cases in our brief, which we provided to you,
This letter matters
where
a
courts
lot.
precluded discovery on matters that were irrelevant or not reasonably calculated to lead to the discovery of admissible evidence. Just to give one example, in Hoogland versus Dollar Land Corp., 337 2nd 509, 4th DCA 1976, the court held the appellate Hoogland was entitled to a protective order as to most of the
For those of you asking about the judge has the letter.
material sought until such time as it may appear that discovery of those documents is relevant or that may reasonably lead to relevant evidence.
It's relevant.
So
You
while
wouldn't
not
be
the only
fighting if
factor,
it
relevance
wasn't.
is a
Well,
significant
no, you might be.
part
but
of the court's consideration.
This
The
is,
plaintiffs still
I
have to
think,
comply
relevant.
with Rule 1.280B, which only permits discovery regarding matters that are relevant
The judge
or
has the
reasonably
letter.
calculated to lead
Yep.
to the discovery of admissible evidence.
Why do you believe that this letter would, you've seen it, now I've seen it. Why do you believe that this would not be relevant?
Well, Your Honor,
Yes, Your Honor.
As Mrs. Laundrie's affidavit states, it was written.
Aside from statements made by your client, which arguably have a credibility factor that has to be addressed by a fact finder, what would be the reason that this would not be relevant?
Well, Your Honor,
Because we
I
hate
can't
it.
use the affidavit and I can't use.
Your Honor, because we hate it. It's not relevant because we hate it, and we don't want you to turn it over. Did it work? Did it work? This poor lawyer is having to do like Unikitty. Business, 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 business. Is it working? The court's like, tell me how this isn't relevant. He's like, so I can't. Look, he's making the face and everything. He's like, I can't tell you that. The judge is going to turn this over, I think.
That has to be addressed by a fact finder. What would be the reason that this would not be relevant?
Because it's really bad for us.
Well, Your Honor, if I can't use the affidavit and I can't use the actual words of the letter, you know,
I'm
to
kind of
describe
fucked here, Judge.
why it wouldn't be relevant, I'm not frankly sure what to say, because those are the two, the actual content of the letter and Mrs. Laundrie's affidavit are the reason why it's irrelevant, because
What the court said about credibility is that there is a credibility concern because it is a self-serving statement of a party that is unopposed. No cross-examination, no nothing. So the court cannot rely on Roberta Laundrie's statement alone. The court's not saying Roberta Laundrie, this human is not credible. The court is saying this is a party who is making a self-serving statement. And in that circumstance, without cross-examination, you can't just take it at face value. It has to be examined. That it's an adversarial system. That's why.
she says she wrote it before Gabby and Brian went on the trip.
Okay.
Regarding the context of the letter was going to be that shows that it was written before they went on the trip.
Because this sounds like an argument that you make at trial.
Yes.
When everybody has seen what you're trying to present.
It's a motion in limine
And then at that point in
argument.
time, we dire the witness, we make some credibility
Yes.
determinations, and then we decide whether or not it's relevant or not relevant.
This is a motion in limine argument.
Rather
He's-
than at protective order discovery stage,
Yes.
where we're bringing in Mr. Riley here with his hands tied behind his back, not knowing how to argue it.
Yes.
I mean, essentially, when I took away the affidavit and the words of the letter away from you, I essentially put you in the exact same position that Mr. Riley is now in.
Yes.
I understand, Your Honor. I mean, but certainly, he has the affidavit. He has the ability to develop additional evidence through the course of discovery, take Mrs. Laundrie's deposition, stuff like that, where perhaps he could
I
develop.
think the letter's getting turned over.
I'm not suggesting that. I'm just saying that the only facts that we have at this point are the facts that we have.
It's just bad for us, Your
We're
Honor.
very early.
Right. And Your Honor, the reason why, this letter is particularly sensitive is even the plaintiffs acknowledge in paragraph 20 of their response that it is understandable that the Laundries would argue that the letter is embarrassing and most prejudicial to Roberta Laundrie. And our concern in this case.
She talks about baking a shiv into a cake if Brian Laundrie goes to prison. I don't know how else you say that, but I think the letter's going to get turned over. Okay, let's get going.
But that's not to be fair, that is not an argument for discovery, not being required to turn over something in discovery. That is an argument
Accurate.
for a motion in limine.
Well, no, Your Honor,
Yes!
it is an argument for discovery because
No!
under the standard for the protective order, if something is embarrassing, it can be protected. Okay.
But that doesn't mean it doesn't get turned
in this
over.
situation, what we have is something that is embarrassing, and given the media attention on this case.
Sir, you can ask for a protective order that it not get disseminated to the media, but you can't keep it from getting turned over to the Petito's attorney.
And how this letter could, would be put out into the public potentially.
The
It's-
public wants to
it's
know.
unfair.
Are there, and please correct me if I'm wrong on this or lead me in the right direction on it, but there is case law that suggests that the protective order does not necessarily prevent the other side from getting the discovery, but rather prevents the dissemination.
Yeah.
I mean, is there a middle ground here rather than,
Yes, there
plaintiffs
is.
do whatever they want to with it? And
Yes, there
you saying
is.
it never gets to see the light of day. Is there a middle ground here?
Yes.
Where we can proceed and actually give them some meaningful attempt to utilize it and determine whether or not it would be a relevant.
Yes,
exhibit
there
for
is.
trial?
There certainly could be, Your Honor. I mean, we could, if we wanted to, we could work something out where we do enter into a protective order whereby Mr. Riley could see the letter and then.
Because that's not my understanding of what you're asking for in your protective order.
Right, that's right, Your Honor. I'm
Your
asking-
order is like,
Correct. You have asked that it not get turned over in discovery. The appropriate ask is, Your Honor, if you find that this is discoverable, then it needs to be protected so that this letter is not disseminated, that this letter has a protective order on it, the way you do with sensitive witness information and medical records. You conceal it, but you still don't get to withhold it from the other party. He's trying to withhold it from the other party, which isn't going to happen.
I wanted to be shredded and gone and forever and ever.
Right. I am asking for a Rule 1.280C protective order, meaning we don't have to disclose it, as opposed to a
Wrong.
protective order where Mr. Riley and I agree to some terms as to the protection of it, like how it can be used, who can see it, things like that.
That's what's going to happen.
Now, that's something we could certainly work on. Although, Your Honor, I mean, I think I would be remiss without saying that regardless of, if you totally disregard Mrs. Laundrie's affidavit, totally disregard.
I'm not saying that I am.
No, I understand.
I'm asking you the questions so that I can see the full crux of your argument.
I understand. It's still, there is still a requirement that discovery is limited to those matters that are relevant to the litigation as framed by.
If it wasn't
parties.
relevant, you wouldn't be arguing this
So in
much.
this situation,
It's my argument.
the plaintiffs don't dispute that they've never seen the letter. They don't dispute that Mr. Bertolino's, I mean, other than maybe.
The plaintiffs, he just said the plaintiffs don't dispute that they've never seen the letter. The plaintiffs have seen the letter. They don't have the letter. They have seen the letter. They are entitled to a copy of the letter. Do we know that the letter exists? Yes. We know that the letter exists. And the FBI, I think, also has a copy of the letter.
In his association with this case has seen the letter, but that he saw the letter at the time he issued his statement, or that it had any influence on his statement, or anything like that.
They have alleged, however, that the defendants knew that Ms. Petito had passed.
Yes.
And knew of the location in which her remains laid.
Yes.
And that factual allegation is one that they will have to prove in order
Yes.
to be successful at trial. Because
Yes.
without knowledge, then so while this statement may not have been the one to have caused the intentional infliction of emotional distress.
Yes.
It is the ramp up to that.
Yes.
It's the elements that, it potentially could allow the elements of that to be proven. Does that make
Correct.
sense?
No, it does make sense, Your Honor. I mean, I can understand
That's what I
that,
said.
perhaps, but again,
I went the wrong way with my fan. Damn it. Damn it.
I can't reference the contents
Oh,
of
I just scared my
the letter,
cat.
so I'm just trying, I'm skirting a little bit to make sure that those words don't come out of my mouth.
Judge, I don't know if this would be helpful, but so it sounds like what we're really talking about is whether a confidentiality order should be in place. And,
Yeah.
and in all fairness,
Yes. That's exactly what we're talking about. Saved by Bertolino's attorney. The Laundrie attorney is like, la la la. And the Bertolino attorney is like, let me help you. We need a confidentiality order. But here's the thing. That's not what I just scared the crap out of my cat. That's not what the attorney for the Laundries wants. He doesn't want a confidentiality order. He doesn't want the Petitos to get the letter. Bertolino's attorney realizes that that's not what's happening. So he's just getting it.
I think we've probably asked certain things from the plaintiffs in terms of written discovery where that may not be a bad idea. But of course, if you sort of start the discovery process without one, it's harder to get back in.
That's fine.
So perhaps whatever ruling the court makes, we at least would have some grace period to consider putting a confidentiality order in
That
place
shouldn't
because that
be a
might help
problem.
alleviate everyone's concerns for other issues moving forward as well.
Well, counsel, that's eminently reasonable.
To consider.
That's not
wanna hear,
what counsel asked, though.
Mr. Luke, I have interrupted you a lot.
Oh, no, that's
You are
fine, Your
helping-
Honor.
You are helping me out, so I appreciate that.
Eminently
I
reasonable.
appreciate the indulgence.
Yes, of course,
Even though
of
if
course.
it's annoying, I'm sorry. Mr. Riley, would you like to?
Yes, Your Honor.
Your Honor, you're not annoying. Don't apologize. He was not making a
As the
direct
court well
point.
knows, we're not suggesting that the letter caused emotional distress to my clients. We're suggesting the letter, if determined to have been written after Gabby passed away, is proof that they were aware that
That they
Gabby passed
knew.
away at the time that the statement was made on September 12th.
Yeah.
That's the importance of the letter.
Yeah.
As we all know, the letter references burying a body, bringing a shovel and burying a body,
Shiv.
taking a cake and putting a shiv in it. Those are criminal acts, by the way, that Roberta Laundrie has said she would commit. But those words are in that letter.
I don't think shiv's in the letter, but.
Or then a saw or something, baking something in a cake.
Wait, Shiv's not in the letter?
And by the way, her reference in her affidavit to these children's books that
Oh,
has
shit!
tried to explain
He brought
why
the
she wrote
books!
that letter to her son is ludicrous because there's nothing about.
I would have done that too. I would have done that too. He brought the books. He brought the books. He read the children's books. God, if you haven't watched today's podcast, you've missed a lot. Do that next.
Burying a body or bringing a shovel or putting something in a cake if somebody goes to prison, although Mama Bear did say she would bake Little Bear a cake on his birthday. This whole argument is based upon the affidavit of Mrs. Laundrie. Mrs. Laundrie is a party. Mrs. Laundrie has bias and prejudice and a reason to say the things that she did in her affidavit. And if I were in her shoes and I had written that letter, I'd probably say the same
You'd
thing.
fight like hell
But
to
that
keep it
subjects
out.
her to a credibility determination, and the court can't determine her credibility based upon that letter, and credibility is for the jury to determine.
Those are the
cases
receipts.
that I cited regarding relevancy, are all second, two of them are second DCA cases, one is a fifth DCA. None of the cases that Mr. Lucas cited in support of his position with regard to relevancy are second DCA opinions. And also, it's their burden at this point, to show good cause to protect them from annoyance, embarrassment, oppression, or undue burden or expense that justice requires. Well, I haven't heard from them what justice requires under this circumstance that would entitle them to a protective order. But the basis of their argument is relevancy. And again,
That's for a motion in
Mrs. Laundrie has
limine.
admitted she wrote the letter. The
Cart
counsel's
horse.
admitted that the letter is undated. It's up for a jury to determine, or up to a jury to determine when the letter was written.
Motion in limine.
But I cited the case, the court to the HEPCO case, which says relevancy is not a proper ground for protective relief under Rule 1.280C, and that's 301 Southern
Yeah,
3rd
this is gonna
406. It's a
denied.
2020 second DCA opinion. I cited the court to Dees versus Kidney Group, a 2009 second DCA case, which says it upheld the
it
circuit
should
court's
get denied.
finding that the information sought to be protected is not related to any pending claim, and it is not and the fact that it is not reasonably calculated to lead to the discovery of admissible
I think a
evidence is not
confidentiality order is
sufficient
fair.
to issue a protective
I don't know
order.
if you need to argue
I
anymore,
also cited
counsel.
the case of Kiker
I
versus
think the
Lopez, a
law's
fifth
on your
DCA case
side.
from
I think the
1998, which
judge
held
is on your
that
side.
holding that the argument
already
that
had your
information
moment
is
with
not
the
relevant
books.
to the issues in the lawsuit
I don't
does
think there's
not
more you
satisfy the
need.
moving party's burden to show that producing the requested information would subject him to annoyance, embarrassment, oppression, or undue burden or expense.
Oh, if this goes to trial,
The
I'd
simple
bring the
fact that
books.
it might cause her embarrassment is in and of itself not sufficient
I might need to get the books.
to issue a
New books
protective
for members
order in
only.
this particular case. We're not talking about compromising pictures. We're not talking about financial information. We're talking about something penned in the handwriting of a party to this particular case. The cases, none of the cases that were cited by Mr. Lucas support the suggestion that a protective order can be issued based upon the affidavit of a party, not one of them. That basically what they're asking you to do is to make a credibility determination at
Yep.
this point, which will preclude me from moving forward with a certain piece of evidence, a critical piece of evidence in this particular case, to show what information
Agreed.
the Laundries had at the time that Mr. Bertolino made the statement.
Agree.
So I don't see any grounds upon which they're entitled to a protective order in this instance.
Agree. I think it should be denied. Agree. Totally agree.
Say I agree with you, Mr. Riley. What argument would you have against a confidentiality?
Probably none.
I have no reason to agree to a confidentiality agreement. I mean, that hampers me. Why would I agree to a confidentiality? So then if I'm asking her about it in a deposition, so now the
Why?
deposition is going to be, the deposition transcript is going to be confidential as well, or a portion of it? I mean, I don't see a reason why I need to be hamstrung. We're not talking about financial information, which would be the appropriate subject of a confidentiality agreement. We're not talking about trade secrets. We're not talking about something that if is disclosed is going to give some party an advantage, an outside party an advantage in moving forward, such as if trade secrets were disclosed. That's not what we're talking about. We're talking about a letter in the handwriting of a party.
Yeah. Interesting.
Mr. Lee, would you have something to add to that?
Your Honor, I think at this point, we probably wouldn't be in favor of a confidentiality agreement on this issue either, just because Mr. Riley just put probably the two worst parts of the letter on the record in open court. So, I mean, and that's what we would be dealing with that throughout the.
They were already in his motion. So, I mean, the shit's kind of out of the horse for everybody on this one. But he's like, why would I bother? Why do I need a why would I give them anything at this point is what he's arguing, which is fair.
Litigation. I mean, he can.
Okay, so
you
y'all
know,
don't want to, you just want me to rule then?
I think
Yep.
we just want you to roll.
Okay, very
Yeah.
good.
Okay. Denied. Ruling denied.
Well, that made that decision easy.
Yeah, this is getting denied. The court's like, well, that make that decision easy. The court's denying this motion. Or at least that's my reading of what this judge is going to do. So. And then it seems like we will get the rest of the ruling on the motions to dismiss by written order later. So I'll be keeping an eye on those in the next few weeks. So, all right. The judge is getting prepared to rule. At least the ruling's not going to get put over.
Reviewed defendant's motion for protective order and all applicable responses, as well as heard all of the argument given here today. And both attorneys, I appreciate both of you answering my questions. I really do. And at this time, I am going to be denying defendant's motion for the protective order.
Yep.
Are there any other objections with regard to this?
I think that was the only way that was going to go.
Discovery that are currently pending.
No, Your Honor.
No, Your Honor.
Would Mr.
Oh, we're
Luca,
almost
is there any
done.
reason why I would not be able to give Mr. Riley the letter today, or if you all have an extra copy,
Give it to him now.
precluding me from doing that?
The only thing I would want to do would maybe put a bank stamp on it. But
Absolutely, that sounds.
other than that, I mean, I suppose you can just give him that copy, and I can bait stamp it, provide him with that like at a later time, just so he can keep a record of like where that document
Sounds
falls
good.
within the
Yes.
range.
Does that work for you, sir?
It does.
Okay, and would you do the proposed order?
I will.
Okay, very good.
Okay. The court's going to give him his copy. He's going to walk out of court with a copy of it. Then he's going to get a bait stamped copy of it. He's going to write up the order. The court has ruled. The court is going to give a ruling about the motions to dismiss at a later time. A Bates, B-A-T-E-S stamp. So you stamp discovery so that each page of discovery has a number sequentially, so that every single number or every single page has a number. So when you're looking at something, everybody knows it's page 1131 or whatever, instead of going this motion, that motion.
Okay,
It's
I don't
a way to
mind
keep
giving
order.
this one, I just need to-
Bates.
I was
stamp.
gonna stamp it and sign it as the one that was.
It's a way to keep order of your discovery.
All right.
It looks like a photocopy of the letter.
No, probably not. Okay.
Do you want to trade out? Just
Looks
the
like a
back of-
long letter
Yeah. May I approach, Your Honor?
Yes.
based on what we
Mr. Riley,
saw.
Do you have any issue with me putting my initial at the bottom here as the one that was reviewed in court?
I do not.
Okay.
Okay. So, all right. Will we see the letter? Probably not. This attorney's, that was his worry, that this would immediately end up in the public. So no, do I think the attorney for the Petitos is going to immediately turn around and give this to the media? No, I don't. I don't know if that helps their case. And apparently the two worst parts are already on the record. But I think reference to this letter will continue to come up, and I think we will learn more about the letter in filings. And I think that's how we will start to hear about the letter. So no rulings today other than the letter 88 keys. That is correct. But here are the rulings. 1, again, you've made this the #1 place to watch live trial coverage. Thank you, Law Nerds, you rock. 2, don't forget to subscribe to the channel. 3, y'all are smashing it on today's podcast. So if you have not listened to today's podcast about all of these motions that we just saw one ruling for, go do that after. You've got time. I'm going to get to questions in a minute. The court is finishing up their procedure. I'm not going to turn it off until we're done with kind of the regular stuff in court, but they are just about done with this ruling, and we'll be there when we get done with this. So they got the letter.
Else that I need to take care of today.
Any further motions?
No, I don't think you. Thank you.
Thank you. It has been
Everybody's
an
done.
absolute pleasure to work with all of you today, and we will
That's kind.
we will see each other soon, I believe. And I will
What's-
have an order for the motions to dismiss out shortly.
Thank you, Your Honor.
Thank you.
Hey, Judge.
So the court will be ruling on the motions to dismiss shortly. That can mean anything from a few days to more than a few days. And that is the end of these court hearings today. As Judge Newman would say, we've done enough work for this day. That was a long hearing. Those attorneys both talked for like an hour in the motions to dismiss. I didn't think we were getting full oral argument on the motions to dismiss today. Let's do a quick summary and then we're going to get to questions and then I got to go. Look, it's a busy day. We've got a lot to do. A, I have a meeting in a little bit. B, tonight's the first part of the Vanderpump Rules reunion. But what happened in court today? There was argument on the motions to dismiss from the Laundrie parents and from their attorney, Stephen Bertolino. The court has reserved ruling on that. A written ruling will be out shortly. I don't think that's today. Might not even be tomorrow, but we will see a ruling on that down the road. I don't think the case is going to get dismissed as to the Petitos. I think there's interesting arguments with regard to Stephen Bertolino, but even if the court did dismiss it, it would probably be without prejudice to allow a further amendment, but we will see what the court decides to do. The previous judge has already denied 2 motions to dismiss from the Laundrie family. If I said Petito, I apologize. The discovery with regard to the third request for discovery with regard to financial transactions was dealt with. There were none to turn over, and that was done. And then the court ruled on the protective order wherein the Laundries were trying to keep Roberta's letter to Brian, wherein she references bringing a shovel to bury a body, from being turned over in discovery to the Petitos. The court denied that motion. The letter's been turned over. We will see argument about this again in motions, and we will see argument about this again when it comes to motions in limine, the motions before a trial. We've got a long way to go before this case gets to trial, but we will see all of this again, and we will see more of it in court filings, I am sure. So there's not even a confidentiality order, which is great. So there you go. We'll hear more about it. I think that was, I think those were interesting hearings. I'm not surprised by the way that the court handled that last motion. In the podcast, I thought that that was going to get turned over. At the beginning of today, I said I thought that that was going to get turned over, but that's a big win in court for the Petitos in a case that is not an easy case for them to get to trial. There's still a lot of lifting to do. We have to get to the summary judgment motions and what have you. So those are the court's rulings, and that's what it is. I see some of you asking in the chat about a ruling on Bertolino's motion. There was no ruling on Bertolino's motion. The only ruling that this court made on the record before ending the day was to deny the motion for protective order from the Petitos and to not turn over any additional information on the financial records on that third request. So that's what happened today. You've got questions. I've got questions. I'm going to do as many as I can. I might not get to all of them. Huge thank you to the mods today and for all of you for being here. So go ahead and do the YouTubey things. Thank you. Let's get to questions here. Let me change my screen around a little bit so I'm not staring out the window. To the window. Yep. I am so ready to watch Vanderpump. Are you ready? Y'all, are you ready for the part 1 of the reunion tonight? I am ready. I am ready. I'm ready to go out to dinner. I have a meeting, but I'm ready to go out to dinner. I'm ready to watch Vanderpump. I'm ready to have some whiskey on my porch with Octo. I'm ready for Dave Matthews Band weekend. So if I seem distracted, it's because I already want to have my hair pulled up in a hat drinking whiskey. So, Lori asked the important questions. Are we all annoyed? Wait, did I play the bumper? I don't think that I did. I don't think that I did. My computer is running so slow right now, so I apologize. I'm going to see if I can ease the burden on my computer real quick. And it is just computer painful at the moment. So hold on. I am having a hard time selecting comments and questions because my browser is just like, hey, you're adorable, fuck you. So that's happening. All right, questions. All right, let's get to some of our questions. And we are getting ready to roll. I can't pull them up. I'm going to look at the chat. So if I don't get your question pulled up, I apologize. I am trying. The hair is a mess. The computer is a mess. It's all the things. It's all the things, but my browser is just pissed. So I'm not going to put on, I normally put on our StreamYard lo-fi music in the background, but my computer is giving me so much business that I don't think I want to try to stress it anymore. EM in the chat said, question, what do you think about the strategy of the Laundries not appearing in court? As I'm reading one, another one pops up for me. I think the Laundries don't want to subject themselves to public eyes. I don't think they want to be seen in court. I don't think they want people interpreting what their faces look like. They don't need to be in court for these motions. I don't think they want to be there because people are going to look at how the Gabby Petito's parents are acting. And and comment on whether they appreciate their comments, don't appreciate their comments, appreciate that they're laughing in court, don't appreciate. People are going to make comment on it. I think the Laundries don't want to submit themselves to comment. Ann Bell said, I feel you, my desktop computer died last night. It's been a very busy day today, and my computer is just, my computer is having all of the things. Amy D said, okay, but wait, BK's parents were called by grand jury in Pennsylvania. I know nothing about that. So if that is being reported, I would have to go look at reports, which I can't do at the moment because my computer is like, hey, girl, no. Did you hear about the guy who was arrested for stealing a pair of ruby slippers from the Wizard of Oz? Yes, I've already grabbed it for next week. And Taco Bell and Taco Tuesday's on my list too. We need another food court. But court, you guys, if you want to stay on top of the cases that I'm covering, if you want to know when I am streaming, you need to go join Law Nerd Alerts because the schedule for the summer changes a little bit when kids are out of school and when I am traveling a bit. So if you want to know, lawnerdalert.com is a free email list. It will keep you in the loop. We are working on a new system to keep you completely as up to date can be. But lawnerdalert.com is the fastest way to know when and where I'm streaming, have links just sent to your email so you don't have to rely on the system here on YouTube because sometimes it has delayed notifications and such. So Law Nerd Alert is the way to the where to be if you want to know. Diana asked in Super Chat, is relevancy a legal term? Daryl Brooks used it, but relevancy is a legal term. Daryl Brooks didn't always use it properly, and it's not at issue yet. For evidence to be admissible, it has to be relevant. First of all, it has to matter. It can't be something completely extraneous to all the rest of it, right? So it has to matter. It has to be relevant to the case. And I can go back through the evidence code definition of relevance. I'm not going to at the moment, but it has to be relevant to the proceedings at hand or answering a question for the proceedings at hand. Then it has to be not more prejudicial than probative. It has to be more helpful to a jury than prejudicial to the party. And that's a balancing act for the court. And that's why we have motions in limine before things go to court, for the court to determine if it comes in. First, it must be relevant. Then it must be not more prejudicial than probative. Then you get into the, is it hearsay? Is it this? Is it this? The other items of evidence. The evidence takes an entire year in law school, but it takes a legal profession to truly understand evidence and argue it well. Zoe asked in Super Chat, if this case is going to trial, are we covering it? Yes. When it goes to trial on the court website, it still says that it is going to trial on in August, but JB today, and I trust JB's reporting, JB today said that that's already been put over to like a year from now. So I am not sure what's happening. Let's see. Miguelina, I saw that you included a link for me. I'm not sure what the link is. Oh, there's a press conference outside the courthouse. Okay, I see it. Let me go take a look and see, queued up. Do you know when the press conference was or how long ago the press conference was? Because I am not seeing it. Is it not happened yet? Let me know in the chat because we'll go to JB's coverage in a minute, or I will throw you guys to him because I do have a meeting. So let me know, Miguelina, in the chat, or chat, let me know. I appreciate that. So thank you. Let me pull this over so I can see the super chats a little bit better and keep that going. If there is going to be a press conference, we will go to it. It already happened. Okay. Hey, ADB and fellow law nerds, very excited to catch a live, usually replay crew. Love watching your commentary. I love giving commentary on live court proceedings. Let me go find that real quick, chat, because I am curious to see the press conference. I mean, it's a win for the Petitos today in a case that's going to be very difficult for them. This is not an easy case. There's some cases we look at and we're like, oh, this needs to go to trial, whatever. This is not an easy case for the Laundries legally. They are not legally in the easiest position to argue. So let me back up and go see if I can find this press conference that happened after court was done. See, that's still the court hearing. I'm almost there. Okay, that's JB in the studio. There's microphones set up. All right. I think I'm there. I'm zooming. Okay, hold on. I'm zooming. We're zooming. I know WFLA had it, but I've got to zoom into the live coverage to get to the right spot. So we're doing it. We're finding it. Y'all stretch. It's time to stretch. Ugh, it's time, y'all. And we found it. Oh, Miguelina, our producer, is an absolute godsend. I could not do this without her and the mods. Our mods are amazing. All right, let's throw to this press conference over on WFLA real quick. We're gonna cover the press conference and then we'll see where we get from there. If I do not get to questions more, I apologize. Let's throw a swoop in there when my computer just rude. Let's throw a swoop in there. We're going to the press conference outside the courthouse covered from WFLA. And now I tried to swoop it and it didn't swoop. This swoop today, my cats. That's the wrong screen. Hold on. Pause. My share screen is buffering. Y'all, we are professionals here. I apologize. Let's do it this way. Did it mute me? That was rude. If I was muted that entire time, I am mortified now because I can't see the comments. We're professionals here. Sorry. I am trying to share my screen and everything has gone crazy. Oh, that's a big rabbit. Sorry, distracted. All right, y'all. Do we have, there we go. Chat. Today is just one of those days where my computer does not want me to do things. And I apologize. Let's go to this. Hopefully. Oh, that's
You're
muted.
live on WFLA now.
You guys ready? Yeah. Could you just say your name and spell it so we get it correct?
Matt Luca, Luka.
I guess,
Matt Luca is the attorney for the Laundrie family.
how are you feeling after all the motions? We know that the judge is going to rule on 2 other motions as well. Just how you feel moving forward right now?
Well, it was obviously a long day, and we appreciate Judge Brewer giving us as much time as we needed to take. She was very accommodating in that regard. I feel pretty good. Feel about as good as I did walking in. We were able to make all of our arguments, and hopefully they'll be persuasive.
I'm sure you're hoping that.
With letting them use the letter as well, we know that the letter has now been handed over to Mr. Riley. What are your concerns in that aspect?
Well, obviously we were concerned about how the letter might be used, that it could be embarrassing and whatnot. But it's part of the case now. It's part of discovery. And so I'm sure it's something that we will address again as the case progresses.
Is there anything else you'd like to say about that letter? We know that we were told that there was references to children's books, but just hearing Mr. Riley, it didn't sound like that.
Yeah, we disagree with Mr. Riley's characterization. So within the letter, you'll see that there are references. I know Mr. Riley referenced 2 things in the letter that, taken out of context could
Look
be
bad.
inflammatory, but they appear in a series of sort of fanciful descriptions of how much somebody would love somebody else. So, for example, there's a reference in there about if Brian went to the moon, his mother would be waiting for him to come back. If Brian hated his mother's guts, that she would get new guts. Things that are obviously not real. They're just fanciful descriptions, again, of how somebody would love somebody no matter what. And so in that context, we believe that
You can also just say, you are my child and I love you no matter what. However, here's what I'm thinking. Y'all, let me know if I am wrong, if you are with me, if you think something else. I want to know your thoughts. That's why we crowdsource. Couldn't couldn't his argument saying she's expressing I love you no matter what also be interpreted that Roberta Laundrie is saying to her son, no matter what awful shit you have done, e.g. murdering your fiance, I, parent, still love you? Because the descriptors are kind of over the top. And I think this can be argued both ways. I love you no matter what, I think indicates to me that perhaps this letter was written after Gabby Petito died and when Roberta Laundrie knew that her son was a murderer. Because why else do you need such strong descriptors to say, I love you no matter what? You know, if my kid, who's not a driver yet, and I'm terrified for the day, but I also think it'll be great because all the mixed emotions. But if my kid comes to me and is like, Mom, I hit a curb, I scrapped the rims, I hit a deer, whatever it is, I would be like, first, are you okay? Second, were you texting on your phone? Because, oh my God, don't. And third, we'll figure it out. It'll be okay. But the descriptors in this are so over the top. It just leads me to wonder if the interpretation of this letter is it was written after she knows that her son has committed murder. Chat, what do you think? Let me know what you think. A lot of you are like, yep.
The letter, as Mrs. Laundrie said, was written prior to Brian and Gabby's trip. The letter doesn't reference Gabby in any way, which would be unlikely.
Does it have to?
If it was written after what happened between Gabby and Brian. So that's our position, and we believe the facts will.
But doesn't or couldn't I love you no matter what reference what he did? And maybe it doesn't reference Gabby because they know that she is already dead.
We'll eventually bear that out.
Can you prove that the letter wasn't given to Brian on his flight back to Moab?
Good question.
Again, other than what Mrs. Laundrie has stated in her affidavit, that's our proof. There's certainly no proof that she gave it to him at that time that you described.
I just don't
Roberta says so.
think that they would put burn after reading if it was just a letter to your son.
Who's asking this question? She wouldn't just put burn after reading if it's just a normal letter. Good question.
If you look at Mrs. Laundrie's affidavit, she states in there that that's a reference to a book that Gabby had given Brian that was called Burn After Writing. And basically the premise of that book is you can write your personal thoughts down and have that outlet, but then you burn it after writing it so that it gives you some closure to whatever it is that you were describing without other people knowing your personal.
Yes. We are all familiar with burning things. Look, we watch Vanderpump Rules. There was lots of burning of intentions and what have you. We get it?
Personal thoughts.
Thank you.
Thank you.
All right. I don't know if anybody else will come up.
Matthew Luca speaking here
I don't know if we'll see
outside
from
the
any of the
courthouse in
other
the
attorneys.
aftermath of
There's just
a
like
lengthy
watching this attorney walk off in an awkward way. I don't know if we'll see any other attorneys come up. If we do, we will. Oh, yep. Here we go. I'll get to questions after this.
Riley.
This is the attorney for the Petito family. JB just said this is Pat Riley, which we knew. Waiting for his clients and the family members of Gabby Petito to come and join them.
Mr. Riley, how do you feel? We know that the judge has 2 more motions to make a ruling on it, but as you said, that Judge Carroll had really already...
The media's
made these
hard to
rulings.
hear.
It's almost a disgrace to his credit as a judge to go back to...
I would agree. I think the arguments that were made, if I were Judge Carroll, would be insulting to me because they argued that he didn't give a thorough consideration to all of the elements of the cause of action, which is clearly not true. His decision
I like the jacket.
was very well written, very reasoned, and he took his time putting it together. So
Let me
I
move
think they're just
myself.
seeking another opportunity to raise the same arguments, and they should fall.
Are you concerned that, I don't want to call it a waste of time, but that they'll continue to drag things out with motions like this?
Well, if the court denies their motions, then there's nothing more they can do to stop it from moving forward. We'll begin or continue with the discovery phase and then ultimately move towards trial.
How do you feel getting that letter in your hand today, too, as well?
It's
Florida.
a victory. We're happy to have it. We fought hard to get it. We've been fighting for over a year to get that letter.
Wow.
And once you have that letter, we've heard some of the phrases, some of the wordings that have
Ask. This is what I love about the media. The media is like, now that you have that letter, could you just pull it out and read it to us, please? Ask the question. He's got it in his hand. We saw the court give it to him. Ask him for it now.
that were written in that letter. How do you think that will help the case moving forward?
Well, the letter suggests that Roberta Laundrie
Tell
would,
us.
if she needed to bury a body, she'd bring up a shovel and garbage bags. It said that if she went to jail, she'd bake a cake with a file in it. I know in court I said shiv, but that
A file makes more sense. If you're going to try to get out of the bars, a file makes more sense than a shiv. A shiv would indicate you're trying to harm someone. A file would indicate you're trying to get out of prison. Trash bags. He's giving us more information. It's giving more information.
was my recollection from a year ago. It does say file. So in my mind, that clearly shows that she knew that Gabby Petito was deceased, and it's up to the jury to decide
I think it's
when
a
that
good
letter was
argument.
written. Just because Mrs. Laundrie says it was written before the trip doesn't mean it was written before the trip.
Look, the I will do anything for you, I love you no matter what, I think can reasonably be argued that this is made after she knows her son is a murderer and she is telling him, I will stand by you. I think that's a reasonable argument to a jury.
I guess for the family, too,
That letter, man.
not having Ryan alive to go to trial, how will this continue to help with some, not closure completely, but just closing out that chapter?
Well, the whole intent of this is to get answers.
Yeah.
There are still many questions that the Petito family has about what the Laundrie family knew, what they did with the knowledge that they knew, and really why they didn't come forward and say anything. I don't know that question will ever get answered because the court has found had the right
don't know if it
not
will
to
either.
say anything. But there's a lot of questions that the family would like to have answered before they can get, if you can get closure at all in a situation like this, but at least
I
get
don't
some
know
closure.
if you can. I think they want some answers, and that's fair. They deserve answers.
All right, thank you.
All right. I don't know if we're going to see any of the other lawyers today. I don't think there's anything we need to see from the attorney for attorney Stephen Bertolino. I don't know if we will or won't. So I'm just going to leave it up real quick and go from there. We learned that there was also a reference in the letter to garbage bags in addition to I'll bring a shovel to bury a body. I really think, given what both attorneys have said, I think there is a very strong argument that this letter is written after. And I think most of you have said yes. If you disagree, please let us know. I'm happy to hear it. Because again, that's why you get a jury together to decide if this goes to a jury, depending on future rulings. So we'll see what happens as we get there. So they are going back to the studio with JB. I don't want to take away from his coverage, so be sure to go over to WFLA and catch that. I'm going to keep monitoring this and see if any other attorneys come in. I doubt they will. I think that I really liked Stephen Bertolino's attorney. He was very measured in his statements, and I really enjoyed the way that he went through his arguments. I found him to be respectful. I found the arguments he made to be good. There are some good arguments to dismiss Stephen Bertolino from this lawsuit. I understand the arguments that he made. I think that's a harder decision for the judge to make, and I think the judge is going to be very mindful in listing out the ruling that they make. So with all of that, let's get back to your questions. As I continue to monitor this to the side, I don't think we're going to see any more from this press conference, though. So I'm going to keep an eye on it, but we'll go from there. So, Jen, it's so good to see you. I've been seeing law nerds all over the internet that are getting our collab and absolutely love it. So it's good to see you. This is a hard case, but this case is in a position to change the way we use the law of intentional infliction of emotional distress. And I think that's a very important thing to cover. And I think it's a very big deal. This is not an easy case. And I think it needs to be said that this is not an easy case. This is not easy to decide. This is not easy for the court to decide. This is a different way to use this particular law. And that is something that very, very much needs to be discussed and covered. I'm just going to scrub through a little bit of the additional coverage from WFLA. Okay, nothing more from the press conference. So we are clear on that. I want to close the browsers because my browsers keep slowing down. And I want to finish getting to questions before I have to scoot to a meeting. So thank you, everybody. I appreciate all of you. Defendant lawyer seems to be using case law from other states. I thought that was frowned upon or not even considered. Your thoughts? It depends if there's not case law in the state. It can be used. It's not as authoritative. So the weight it's given is lower. Sometimes it's all you have is case law from other states. So it just depends. They have some really good cases in Florida that's been cited in all of these motions. I haven't covered the motions to dismiss recently. I covered those in past coverage. I will circle back to them again. When we get the court's ruling, we'll get back to it again. So we'll do that. Stacia in the chat said, best use of physical props ever. Bringing the books in was absolutely fantastic. Doesn't suing a lawyer for things they did said, well, repping someone put them at an unfair disadvantage in their defense due to attorney-client privilege. He can't say if they told him she was alive. This is a great question, HP. I really think that the case as to Bertolino is harder because he was making statements for his clients. He was a zealous advocate. And yes, the attorney-client privilege can hinder what he can say in this lawsuit. So sometimes you can break attorney-client privilege, like for court inquiries and things like that, not in this case, but in a case of like malpractice. But this is a consideration here and a very real one. So I don't know how this is going to fly when it comes to Bertolino. I think arguing that Bertolino was the agent for the Laundries and the statements attributable to the Laundries is different. And I think they're going to look to Depp v. Heard. And we saw the first judge talk about it. We saw the first judge talk about Depp v. Heard and how statements made by the lawyer were attributable to Johnny Depp. And I think we might see that same logic play here to attribute those statements to the Laundries. Oh, this has been a long, long stream. I feel for Gabby's family, but I don't like the idea of being held legally accountable for staying silent, especially when a parent would have to speak against their child and affect their case. Tracy, a very fair position. And the argument here is not that they stayed silent, it's that they made these statements, and these statements themselves are the issue. So staying silent is not the argument here. Staying silent, and you heard the Petito attorney say it today, staying silent means this case doesn't come before the court. This is beyond staying silent. So I'm going to get to a few more super chats, and then y'all, I'm going to have to scoot. I know there are a lot more questions here. And if I don't get to all of them, I apologize, but I've got to get to a meeting. Thank you for your coverage, Emily. I'm going to law school this fall because of you. I don't know what I did. You did it. You got yourself into law school, Sydney. Good for you. Hold on. We're going to do this too. Accepted with $84,000 in scholarship. Sydney, keep an eye. I will be out and about in the Nashville area this weekend. And if you are in Nashville, things that I enjoy. The Parthenon is fantastic. Go to Centennial Park. If you are a Swiftie, she sings about Centennial Park. Go to Centennial Park. If you have time for a nice dinner, Adele's is one of my favorite places. Farm to table. Great, great craft drinks, great bartenders, local vibe. Love it the most. You can actually hear each other talking while you are eating dinner. If you want a different kind of dining experience, the Taco Bell right off of Broadway on 2nd Street serves booze in their slushies with your Taco Bell. It is one of my favorite things ever. Look, I'm basic. Half the time you guys are like, where'd you get that shirt? I'm like, probably Target. The boozy Taco Bell is a lot of fun. Also, Assembly Food Hall is a lot of fun. And those are all things right down there by Broadway. I can't tell you which bar I prefer on Broadway. I can tell you I will be at Dave Matthews at the Bridgestone Center, and then I will be running around Broadway somewhere. If any of you see Dave Matthews running around downtown, let me know. Do you think this case will set precedent? I think it could. And that's part of why this case is very interesting to see. Ruth has asked the question that many of you have asked. Hopefully it'll pull it up. All of the criminal investigations have been closed. I don't know if this will turn up any new evidence that will reopen those criminal investigations. The FBI had this letter and still closed their investigations without bringing any charges. I don't know if we will ever see criminal charges. We will not see criminal charges unless there is something more. Margarita Baker, happy birthday. Glad you're here with me too. Happy birthday to everyone else in the chat celebrating a birthday. Chrissy Ridge, happy birthday to all of the Launards celebrating birthdays. Happy birthday. A lot of you asked about criminal liability for the Laundries. I just don't think there is enough there. And from what we've seen in public, could there be more? Yes. Could that change? Yes. Rachel Mills, I know you were going to be in court for the Britney case. I am very interested to see what's going on. So we will touch in on Britney's case being sent for trial because there needs to be a trial on that 12th accounting. So we will talk about it. Thank you, Rachel, for keeping us up to date and keeping us up to date in the chat. I will be checking in with Britney later. Dancing Beagle, yes, it is. No, you don't just have Doctor Strange on the brain. That is what that is. Though sometimes I get asked if it's a basketball. I'm like, oh no. The nerds know. The nerds know what it is. Law nerds, I have to go. It is so great to see you. I will be Instagramming some when I am watching VPR. So if you follow me on Instagram, that's great. If you don't, that's okay. But that's where I will be in my stories about VPR. Law nerds, I will see you next week. Have a great weekend. I will be around social a little bit, but after that, I will be back here. So with all of it, thank you for being Law nerds. To the new Law nerds, welcome. This is what we do here. Thank you for being such an amazing community. I will see all of you soon. Take care of yourselves. Take care of each other. Everybody, I think we need a pickle cleanse after this. I do. I think we do. Hold on.
I think we need a pickle. Everybody take a breath. Take a breath. And I will see you soon.
Take care, Law nerds. Bye. You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at The Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.